I beg to mention item number 13, 304. I've taken consent of the petitioner side, and the another private respondent is also there, taken his consent also. Time for the respondent number 6, we require some time to find the evidence.
At the request of the Union Council for the petition, responding number 6, matters 93 to be listed after this order to the applications.
There's an interim order. There's an interim order operator. Just continue.
Make it absolute.
It's the petitioner gave me consent, it's my duty to point out that.
Make it absolute. The interim order passed earlier shall continue till the disposal of the petition.
Till the next statement, let me file my.
You should have mentioned at the time when the affidavit is required to be filed. You pick up the matter when the matter is taken up, then you make the mention. Otherwise, why should I? Make it absolute. I'm not fixing a date. Whenever you feel like, when did you appear?
But, it has been a month.
Then why haven't you filed your affidavit? And you have, because I don't grant time out here at the time of mentioning. And if you want it, you take it. We'll make it absolute. In time,
I'm obliged by your lordship.
we'll make it absolute.
Does it make it? Your lordship has passed an order, I'm obliged.
In time order, passed earlier shall continue.
The petition was fixed on today with us. Petition was fixed on today with us. The lordship picked up at today for obtaining instruction, but today matter has not been listed. Can it be on Monday with us?
Was fixed today? Matter was fixed today
Today,
and was not listed. We'll take it up today.
today. Right, please, your lordship. With the consent of the other side, I beg to mention item number 58 of the supplementary. 58 of the supplementary list.
Yes, what is it?
Yes, in this matter, we are required to file an affidavit to bring the record whether the land is hand over to the petitioner. So some time may be granted for the filer affidavit.
Interim order is there? No.
I'm for the
We'll mention when the matter reaches.
obliged.
Here, I beg to mention item number 41. So in this case, with regard to the continue of a market, by the impugn order, the closure of market was directed, but pursuant to the order passed by the Honorable Court, the market was continuing, and settlement period is also over. So I think this matter has become infectious.
You are for the,
I am for the petitioner.
you want to withdraw as it has become infractions? Mr. A. Ali, the legal counsel appearing on behalf of the petitioner submits that at the market period is over. The instant writ petition has become infructuous. He therefore submits that he would not like to press the instant writ petition. Accordingly, the interim order passed accordingly, the instant writ petition stands closed on withdrawal. The interim order passed earlier stands vacated.
I am obliged.
Lordship, I am seeking for listing your lordship. It was last date on 26/7/2022, but it could not be heard, your lordship, due to shortage of time.
Not before vacation. What is the urgency?
In here, the building construction of the petition has been stopped. Your lordship.
Stop. Okay, wait for this. Anyway, it is rainy season. We'll start in the month of October. October, no, not now.
If it is possible,
No,
your
heavens is going to fall. 1 week is left. This court is not in a position to dispose of the matters in this.
on the last date, your lordship. On the last date, I mean on 4th, your lordship. 4th of October.
Court, who is going to take up this matter for disposal? After vacation, mention it, not now.
Lordship, I may beg to stay item number 7, Lordship. Lordship, I may allow to go the matter. Lordship, there is a mistake in the petition.
Withdraw for what?
File a fresh one, Lordship.
Why?
Lordship, yeah, there is a mistake, Lordship. There are some mistake in the petition. Lordship.
What mistake?
Next, sir, page 28, Lordship. There is some typographical mistake also. The text
Annexure, which annexure?
Annexure 6, Lordship.
It has been submitted that there are typographical errors in Annexure 6 of the writ petition. And as such, the petitioner would like to withdraw the instant writ petition. He further submits that he may be permitted to refile by removing the defect insofar as the Annexure 6 is concerned. So accordingly, the instant writ petition stands closed on withdrawal. Liberty, however, is given to the petitioner to refile by removing the formal defects.
Item number 30 for the respondent number 5.
3-0. Yes, what do you want?
Action.
Huh?
Action for the.
Why?
Already
You are for the
number 5.
3-0. 3-0, I have already mentioned it. I'll fix it after vacation. নাই করা দিন।
Lordship, I have to mention item number 49 of the daily news. Your Lordship, the matter is infructuous.
What do you want?
The matter is infructuous.
Item number 45. এই আগৰ এইটো order to type কৰি দিব। Infructuous in time orders you can stand vacated. What is your name? R. Karim. Next.
Please, your Lordship. Lordship, I beg to mention a matter for urgent listing today. Lordship, the matter relates to a petitioner who was a bona fide purchaser of a vehicle who's now being forced by the police to hand over the vehicle, and they are saying that the seller was alleged to have been involved in a crime. So they are being pressurizing the petitioner to hand over the vehicle. Acha.
For listing a matter for and Monday. So.
Yes, what is this?
Action, I have received instruction.
Oh, what is the investigation stage?
I don't know.
Mr. Borua, what was this matter about?
This matter was about a non-completion of the investigation since the year 2006 when it was first lodged. And thereafter that submitted 3 final reports. And we had given an objection before the learned court. And the learned court in all the 3 occasions observed that the investigation was conducted in a perfunctory manner. And the IO was involved in collusion with the accused in returning the final report saying that it is a civil dispute. And without appreciating the evidence and taking witnesses, they had closed the matters. And therefore, on the last order, the Honorable Magistrate had directed them to further investigate the matter until then deferred the case which was pending. And now, since then, there has been no progress. And in fact, there was a previous round of litigation before this Honorable Court, where in fact the disciplinary proceeding against the IO was directed by this Honorable Court, and which was already taken place. And therefore, my lord, there was grave prejudice caused to the informant, because his FIR was not acted upon. And
What was the FIR for?
my lord, this FIR was under sections 448, 427, 379.
Where is your FIR?
My lord, my FIR is at page number 60, my lord, of the petition.
Page number?
60. The information is at 62, my lord. Page number 62 is the information.
So you were a tenant.
Yes, I was.
Now who has done this?
My lord,
Your landlord.
no, not the landlord. The son of the landlord sold it to some other persons who are accused here. And this accused, when I had left for Guwahati from the tenanted premises, they had approached a magistrate and obtained a 144 order prohibiting my entry. So that in that plot of land, 2 rooms were my residence and 2 rooms were my shop. So they had entered during my absence and they had looted my whatever valuables and the shop stationery. And then they had got a 144 order, which I subsequently got set aside. Thereafter, a civil suit was initiated, which I had lost. Thereafter, my lord, my grievance was that
Civil
because,
suit was filed by you.
yes,
For what?
we were saying that we had a verbal agreement with the landlord, who was the father of the, and we had an agreement that after he passes away, then I will purchase that particular plot of land because I had been residing since 1964. Therefore, I wish to purchase it.
So
So
you
there was,
filed the suit, that suit you lost.
yes, that is so. But here I'm only aggrieved by the criminal proceedings because they had entered my premises and they had stolen the things. So this FIR was only limited to the extent that I wanted that a proper investigation be done as to who all had stolen the my materials, and I had specifically named these accused. And my lord, one of these accused was an ACS officer who was back then the BDO of Kolaigaon. And my lord, in fact, he was recently dismissed from service in 2022. I have an order, my lord may peruse. Therefore, he was involved in a lot of corruption cases, because of which he was subsequently dismissed. And he was one of the accused here. And because of his influence, he had manipulated the IO and even the senior officials of the police and had ensured that the charge sheet was not filed. And every time a final report was returned. And when I had submitted my objection before the learned magistrate, every time the learned magistrate was of the view that no, there was a prima facie case in my accusations and that investigation was not done. And hence, every time a further investigation was directed.
But you see now, whatever may be,
Yes.
why you are not now filing a 190 and 200?
My lord, we had already approached by filing 200 CRPC. And then the learned court said that yes, by examining the witness and the informant, a prima facie case was made out. And hence it was transferred to the competent magistrate to take the
When did
proceedings.
you file that?
Hello?
When did you file that?
I had filed it, my lord.
We have filed against the lawsuit that closure of the GRTS. In the FR,
Yes.
in the FR, it is in 156 pages.
One? This is the order.
117.
So my lord, my directly kindly come to lawsuit 160. My next was 160, the direction lawsuit. Page 160 lawsuit. And against this direction lawsuit, we have entrusted it to an IO lawsuit. As per this later lawsuit, that was issuing and against that lawsuit, one additional SP crime was entrusted to inquire the issue. Otherwise, lawsuit, as part of affidavit lawsuit, it's purely a civil nature. So we
No,
file-
no,
we have filed affidavit lawsuit. Yes, because there is a direction of the.
No,
FIR
there is-
which would-
no,
My
I
lord-
don't understand one thing. If you have moved the 190, read with 200, once it is already been the court proceeds to take cognizance, then how can the court refer it again under 156(3)?
They cannot lawsuit. Yes, because probably they have not filed 200 petitions. Yes.
My lord, I have,
Okay.
my lord, my kindly page 117. Page 117.
If that is their lawsuit, then lawsuit, court will own its own.
Informant is
lawsuit, court will
present and
proceed
has
lawsuit.
filed a petition objecting to the FR. No, this is an objection
Okay.
for statement of informant under 200 CRPC. Then 200 CRPC was recorded. Now, once 200 is recorded, then he has to issue process.
Lordship, lordship.
Along
Has
with
been
that,
examined and on perusal of the Iman, a case is made out under so and so. The case is transferred to the courts of I Botaku. Then what happened?
simultaneously also find a petition under section 173(8).
That is against the final report.
Yes. So after that, the learned court had given passed an order in page number
Now,
130.
what has happened to this case?
My lord, this
One, you see, This case, Dolgaon PS case number informant is filed PI for accepting the statement? No. What is this order? This order is passed where? Page 122.
Yes, 200.
200 petition for everyone.
Understood. In which case? What is the number of this
The
case?
Dolga PS case number 278.
No, that cannot be. It has to be a complaint. You see what he has done, fixing for inquiry. Now this is, I think, in CCM Dolgaon PS case number. What is this type of things these courts are doing? My goodness. The court goes to 200, court goes to 200, 202, everything. Issues, case says that he is fit for issuance of process. And then what happened to that case? Should have been the court who should have proceeded.
And complaint case number is also not there also.
There's no complaint case also.
Complaint case number is full.
This meant my lord, I had submitted my objection.
Now what has happened, the case diary, everything is lost.
So that's why Lossi, we entrusted one additional SP crime Lossi yesterday Lossi. Even I have also personally talked with the SP and additional SP crime Lossi.
This has already happened previously, where the IO had been proceeded against. This has again been repeated, my lord. But this, my lord, even in the previous round of litigation, the honorable court had pulled up the IO and directed disciplinary proceedings against him. And now the same has been repeated, my lord. The case diary is missing, my lord. It's a serious matter. So, my lord, this only strengthens my case that perhaps there is a need for press investigation to that extent. Because the state police has not handled the matter at all.
Mr. Burwa, I understand everything. The question is, does it make sense for this court to further proceed with these type of matters any further? I would have understood someday. This happened in 2006. By the time you get any results, what evidence remains?
Let the independent investigation agency just go through it and let them file a report. Because they don't know, because they have not examined any witnesses at all. The only,
What is going to finally happen?
well, the only basis for submitting the final report was that it was a civil matter. No witnesses are examined, I was not examined. My lord, nothing was gone into by the state police. Therefore, my lord, perhaps if a direction comes from the lordship, there is a separate investigating agency just look
Then
into
why
the
are you
matter.
not filing a complaint case?
But Lossi,
You see, first of all, you filed a complaint case and the court made all the problems. The court went to 202. After going for 202, the court could not have relegated the matter under 156.3 or 173.8. Court could not have. What the court exercised in that case, on one hand, taking your action under 200 and 202 and 204, the court again exercised the power under 173.8 and giving it for further investigation.
My lord.
Now, everything has been made in such a manner. What are you going at the end of the day? What is going to happen? Your case is that there is a civil suit pending, and in that civil suit, in spite of that being pending, they have put a wall around you and looted your things.
No, the suit was filed subsequently.
That's your FIR.
The 144 notice was it. They had firstly got a 144 notice.
Understood,
Yes.
they got it, they put what is your FIR? Your FIR is to the effect that there is a civil, you are a tenant, you have a civil suit pending,
Yes.
and in spite of that, there is a wall being constructed and they have looted your goods.
Yes.
What goods?
My lord, since I had a shop, the items of that shop were looted, and also some of the valuables of my residence. The other two rooms were also missing. Hence, I clearly named these accused persons, and because one of them was the husband of the wife, to who by way of a power of attorney the land was transferred. He was backed in the BDO of Kalaigaon, and he was an ACS officer under whose influence the police was acting. Therefore, it was not acted upon, my lord. The courts came to my aid,
So,
directed
Burwa,
further investigation.
I think your client needs to call it the end of the day to this. I would have understood there is something else. You have lost that case also.
My lord, that title suit has nothing to do with the FIR here. This is a criminal proceeding. which has to be
Understood,
kept,
you have
looked
been removed
separately.
from there, that is why you are, yeah, but something has to end. At that point of time, you have to, fine. I can give you the permission for filing a complaint, but complaint case also, these people have initiated it. How can there be double complaint? It can't happen there.
I'll be left remediless, my lord. My lord, may kindly,
And Lordship, FIR also, Lordship, they have stated about the title support. In FIR also, they have indicated title support.
Huh?
In FIR also, Lordship, they have indicated the title support.
yes, I have also mentioned that it was not ruled in my favor also. I have been very clear about it. My only grievance is that whoever entered my premises and took away my belongings needs to be brought to book. And since the police has clearly not investigated
No.
the matter,
Whoever has entered, have you filed a civil suit against that?
no,
One is a criminal case. What is the civil suit filed?
the civil suit was regarding.
Why didn't you, no, did you file a civil suit for recovery under section 6? Why didn't you file then?
My lord, that does not prejudice my rights under the criminal
No,
law.
but what is there to be gone into at the end? Now we are 18 years down the line.
My lord, may just direct that an independent agency look into the matter.
I
Whatever
am not
report they
going to
file, my lord,
direct anything
let them
to the
appreciate
effect.
the
No,
evidence for
nothing.
once.
I'm
Because
not
the police has
satisfied.
not gone into it at all.
You
That
should
is
have
my
filed a
grievance.
civil suit if you wanted for recovery of possession. You should have filed it. Your FIR is very silent. Yes, FIR need not be an encyclopedia, but what did you lose?
My lord, they did not investigate the matter at all, my lord. They
What
would have found out.
investigation? Your FIR said that they've looted my goods. What looted?
That is for them to find out, my
It is
lord.
not even stated from my residence, from my shop. Nothing is stated.
It has, I've mentioned it from my house. It cannot get more specific, my lord. It was the duty of
What
the
was
police to
looted?
investigate.
You can't say that what is looted, but you have to specify. FIR is the first information report. No doubt it is not an encyclopedia, but
Yes.
don't you think that what was looted has to be mentioned?
I have mentioned it, my lord, in page
Where? In
63.
your FIR, where?
Yes, in page 63.
What does it say?
List of articles and its value. Godrej Almira 2 number 8,000 rupees. Paleng 3 numbers rupees 15,000 rupees, and so on, my lord. 10 items I have listed. Page 63.
What is the final report?
The third final report would find that 143, madam. It's 140.
So from investigation, they found that 2 years ago you sold all your goods.
That is not the truth, my lord.
Huh?
That is not true.
Then Lordship, the Bharnegula person, he says that Atmohat.
Yes.
He says that Atmohat.
Atmahat means loot.
No, Mr. Burwa, I don't find this to be a fit case. Anyway, we'll fix it here. We have submitted this report, but this is not a case for taking on a year. This will be go as it is.
My lord, based on the final
I'm-
report,
no,
when the
Mr.
learned
Purva,
court has
this is
observed,
not, we have other matters which requires more urgent necessity. I kept it at top of the list, taking into account this. But nothing is there. So, pursuant to the order passed by this court on 10/9/2024. This court, Mr. K. Gogoi, appearing on behalf of the respondents, have placed before this court an instruction dated 19/9/2024. From the said instruction, it appears that the case diary in respect to Dolgao PS case number 278/2006, which was registered under sections 448/427/379 of the IPC, have been lost, have been missing. And in that regard, an inquiry have been directed to be made by the additional SP crime Dorong Mongoldoy. Mr. Gogoi appearing on behalf of the said instruction is kept on record and marked with the letter X. Mr. Gogoi, the learned counsel appearing on behalf of the respondent submits that some more time would be required in that regard. This matter on 9th of December 2024, on which date Mr. Gogoi shall give an update as regards the status as to whether the case diary, as regards the inquiry, so to be conducted by the additional superintendent office.
See, I have a small problem. I don't know, kindly reflect my name, otherwise I miss out the item.
Is it K. Gogoi?
Oh, that's registered. I don't know, guide the register to reflect my name also.
The registry shall reflect the name of Mr. K. Gogoi in the list.
Okay.
Mr. Borua, this matter you have taken how much? 25 minutes.
So like.
So next, whatever matter comes, everywhere I'll minus this 25 minutes. This is an unnecessary matter which has come.
For motion item 2.
Yes, 2021 motion, we still having it as a motion.
Otherwise, Lordship reading said.
I hope by the end of the year, we may have a jubilee. Yes, what is this? What are you asking for?
Lordship, there are basically two prayers in the writ petition. One is to consider our representation and the other is the reassessment value of the deduct compensation, Your Lordship.
Representation to whom?
Representation filed before the Deputy Commission. This is the second round of litigation, Your Lordship.
Second, third, I am not concerned. For what?
Actually, what happened, Your
Where
Lordship?
is your representation? My goodness, this type of matters, how can it remain? Should have been first.
Page number 128, Your Lordship.
Where is your representation?
Page number 128. The representation dated 15/9/2021.
Reassessment of Jirat standing over. Assessment done,
Assessment done here.
award passed.
Award pass. But the reassessment has been done after we have approached the appellate authority. Your Lordship. There is an order of the appellate authority of the Revenue and Disaster Management, whereby the direction has been given to the Deputy Commissioner to
No,
reassess
after the award has been passed, to whom did you award under what provision?
under the 1964 Act. 1964 Act. Your Lordship.
64 Act, show me where is this appeal lies? Yes, Mr. Majumdar.
Slightly different, my lordship, may just have a look at the detailed order passed on 25th of April 2020.
No, first of all,
My lord,
acquisition done under what
under
provision?
the 64 Act.
Award passed?
My lord, the amount he has taken,
No, award passed. If award has been passed, if he is agreed by the inadequacy, can any other authority except the court under section 12 pass any order? No. And I don't understand why these type of litigations are going on. This is a letter written to the additional AR reassessment on the basis of some order. These orders are non-est. What does whoever we have obtained the valuation report of so and so, you cannot, because once the award
That's
is
right.
passed, it is final. It is a conclusive evidence between you and the collector. And if it is so, the collector tomorrow cannot say, even if the minister calls up and says that kindly change it, give it to Mr. Bodlo, na? Much more money, then also you cannot get it. It is only by the court who can do it. Then this notification with this letter is there with you. You have it. This be treated as an application under section 12, refer it to the court. That's all. Nothing more than that.
now, lordship, may kindly have a look at this order passed. He did not hand over possession. He
That
was
is why notice, the court have also not issued notice.
25th of April, madam.
Of 2000.
2022.
My goodness. Let it be passed. This is an interim order. We consider it to be final. We dispose it of
Otherwise,
nothing
Your
there.
Lordship, they have
And
taken
any
over-
order of this type passed, this is per imperium orders. This can't be as per the context of the act.
This order is not for any other purpose, but for directing him to hand over possession. He did not have, took the money, entire amount, but he was not surrendering. That is, this order was passed.
Again, I don't understand. Land, the moment the land, you do it under section 64 Act or 9, under 6 or 9, whatever may be, the land vests upon the state. Why can't you take over the possession?
Put subsequent says we can apply force to take possession.
You take force.
No, that has been done, Your Lordship.
Now he's
They
saying,
have-
he has filed an
I have
affidavit.
filed an
recently
affidavit, Your Lordship, to
saying
that
that-
effect, that they have taken over possession, they have dismantled my factory, Your Lordship.
Fantastic. Now the question is, the delay in giving is because of that you are not going to get interest. Do you know that? With this 15/9/2021, you have it with your office.
Yes, Your Lordship. Part of
This
it.
is the representation.
Yes.
So you,
Yes, the next-
on the basis of this, you refer it to the court, or you want to file a fresh one?
Lordship, actually, I don't have any contact with my clients.
You don't have a contact is different thing. The contact, therefore the client have lost hope on you because of this type of orders. I'm asking you, if you want to file a one, you can very well file it properly.
Gotcha.
Then you can give it. You see, I don't understand. You can't on the basis of a representation ask. You should file your statement of claim out there itself so that it is referred. This is how it is to be done. Anyways, now, the petitioner hearing heard Mr. G. Bodler, the learned counsel appearing on behalf of the petitioner. Mr. D. Muzumdar, the learned additional advocate general, appears resisted by who? You, Vivian 9. Appears on behalf of the respondent. Numbers 1, 2, 3. And who? You, Mr. A. Kolita. And Kolita appears on behalf of the respondent number 4. The petitioner herein is aggrieved, has filed the incident with petition being aggrieved by the inaction on the part of the respondent authorities in considering the representation dated 15/9/2021 and further seeking a direction upon the respondent authorities to release the compensation as per the reassessed valuation report being conducted on 14/9/2021 by the respondent number 4 within a specified period. Full stop. It has been brought to the attention of this court that the land of the petitioner, what is the land?
I mean, Your Lordship, so that
Land,
means one
How
bighah-
much land?
1 bighah, 4 kathah,
The
11
land of the
acres.
petitioner. It is seen from the records that a plot of land measuring 1 bighah, 4 kathah, 11 acres covered by Dag number 184 of KP Pata number 268 of village Abhayapur, Moza Sinduri Ghopa in the district of Kamrup Rural was acquired under the provisions of the Assam Land Requisition and Acquisition Act 1964. Full stop. This court duly takes note of that duly takes note of that in view of section, this is acquired under which one? Under what provision? Under which 6 or 9?
6.
6, Your Lordship.
This court further takes note of that in terms with section 6 of the Act of 1964. The moment the acquisition notice is published in the official gazette, the land absolutely vests in the state, free from all encumbrances and the period of encumbrance. Full stop. It is also very pertinent to take note of that in terms with subsection 3 of section 6 of the Act of 1964, that the provisions of the Land Acquisition Act 1894 have been, as well as the rules framed therein under, have been legislatively incorporated. Full stop. Under such circumstances, the moment the award has been passed, It is further relevant to take note of that in terms with subsection 3 of the Land Acquisition Act of 1894 with the rules framed therein under have been legislatively incorporated. So, under such circumstances, the moment an award is passed in terms with section 11 of the Act of 1964, the award becomes a conclusive evidence between the collector oblique the deputy commissioner of the district and the persons interested. This award, in the opinion of this court, cannot be unsettled unless it is done so by a proceedings as envisaged under the Act of 1964. It is further seen that in terms with section 12 of the 12(1)(a) of the Act of 1964, the Huh?
Permit me to interrupt. This records show that the requisition was only under section 3. When section 3 notice was issued that we have requisition, then they have prepared an appeal. Appeal court passed an order saying that this is the complaint. Thereafter, they filed it.
No, there is no section 6. Acquisition not done.
Can you see? Acquisition under section 3 only, man.
Huh?
Yes. Requisition under section 3, requisition. Lordship may kindly see page.
No, what is this? Section 6 is there, page 48. Which land is yours? Kameswa Basumatari. In there.
Dock number 184.
184.
Yes, Your Lordship.
That is there, na?
That is good.
This is section 6, page 48. It is there.
Yes, requisition under section 3(1), otherwise in the notification.
This is at page 40.
Got it.
What about 48?
48, Your Lordship.
So section 6 has happened.
It's a LA case number 17 of 2018.
So therefore, in view of the requisition,
Lordship may kindly see what is it? It is hereby notified that in pursuance of section 6 of the Assam Land Regulation 1964, the collector company is pleased to decide the acquisition which effect from the date of publication of this notice of the land, the acquisition under section 3(1) of the said act as per schedule below.
so they therefore make the requisition from that date. Now, if you see section 6(3), the requisition ends and the acquisition starts.
Right.
Yeah.
Now, therefore, the acquisition has already happened. Kindly see this, page 59,
Page 56.
have been acquired. That the below mentioned land has been acquired. Isn't it?
Yes, sir.
That's been followed.
Huh?
Proper procedure has not been followed. Anyway, man, he has taken the amount of compensation also.
No, anyway,
That notification is the Lordship is saying, my lord. That- Yeah.
then we have to set aside the acquisition. Requisition, you have taken it from when? Then if we hold it that it is bad, 2018, 6 years have gone by. So you can't keep this requisition. It is a colorable exercise of power. So we set aside this. What do you say? No, you return it back. You go for a fresh acquisition. Return the land. You're going to do that? If they return you the land, you'll be happy. Mr. Bodley wants that. Okay, we pass that order then.
And this appeal or Lordship may kindly. just-
No, this is not, okay, this is not a gazetted notification. This notification has not been gazetted.
Yes, the page, Dr. Kindly have a look at page 121. Is the appellate order under which manner the land was an agricultural land, but he compensation has been granted under it, as if it's an industrial land. So there was no reclassification in the 2015 Act.
Mr. Muzumdar, I don't understand that submission. The reason why I don't understand the submission is, if you come to this, section 26 to 28 of the 2013 Act applies. If you come to 26 1A, B, and C, there are three parameters on which the acquisition are here. First would be the land value on the basis of agreement, sale deeds and all. Second, which is the revenue value. And third, there is another aspect by which agreement for sales you can have it. The higher of the exemplar is to be taken. But how does it matter whether it is classified as agricultural or not? That land may be of a higher value than immaterial. This is a very wrong notion for which there you find a lot of repetitions filed. That day I passed an order to the effect that this has no relevance out there. Whether it is agricultural or not, that is one of the parameters. If they can show a sale deed, which is of a higher value,
When notice under section 3 was issued, he preferred an appeal challenging the notice itself that you cannot requisition. Now, while disposing of that appeal, the appellate authority says that this is an industrial land, it has been used as an industrial land. So he has to get a compensation under as if it's an industrial land.
first of all, that appellate authority has no business.
That is
out
what I'm saying.
there. Here, has the award been passed?
In the writ petition, he has not said that the award has been passed. He said the compensation.
This matter has been pending for all this while and you are not aware whether the award has been passed or not.
There is no way not.
Very difficult, huh? You have got the money also. So how did you say pay the money without an award?
When you see this order,
And all these unnecessary documents out there. Now, issue notice, making it returnable on 25th of September 2024. Full stop. Mr. Miss, what's your name? So and so appears on behalf of the respondent number 1, 2, and 3 and accepts notice. Full stop. Mr. N.K. Kolita appears on behalf of the respondent number 4 and accepts notice. Extra copies of the writ petition be served upon the respondents during the course of the day. Full stop. The counsel for the respondent, Mr. D. Majumdar, who is the additional advocate general, is directed to obtain instructions as to whether there has been a paper public, gazetted notification in respect to the notification pertaining under section 6 of the Assam Land Requisition and Acquisition Act 1964, and further also obtain instruction as to whether there is an award being passed and when. Full stop. List the matter in the full stop. Not impleadment, no impleadment. Get your instruction on 25th.
better.
Yes, Mr. Bottaku, done.
Chief engineer is trying to comply with the order, Lordship, but the executive engineer is not forwarding the report as to whether it is verified or not.
We issued a contempt as to why contempt proceedings should not be initiated against him.
My lord, I also have instructions. This, the division is the paying authority.
I'm not on that. I'm not on a writ petition. I'm on a contempt. There's a direction to make the payment. We have not made it. So under such circumstances, the question of, on the ground that the verification is underway, Now, the verification has not been completed and it is not been done as such. So, we initiate contempt proceedings against those. Issue notice, making it returnable on 4th of November 2024. The instant contempt application is filed under section 11, section 12 of the Contempt of Court Act 1971, read with section article 215 of the Constitution, alleging willful violation and disobedience of the order dated 9/4/2024, passed in WPC number 2147 of 2022. In the said order, this court have directed the respondent number 3, that is the chief engineer PHE, to verify the claim of the petitioner and proceed in accordance with law within a period of 1 month from the date of receipt of the certified copy. It is further seen that the petitioner had duly submitted the certified copy on when? 29/4/2024. However, as there is no compliance to the order, the petitioner has therefore approached this court by filing the instant contempt application on 5/8/2024. When the matter was initially listed before this court on 9/8/2024, this court initially listed on Iman on 21/8/2024, this court requested the Standing Council of the PHE department to obtain instructions as to whether the verification have been concluded or not. On 11/9 and thereby fixing it on 11/9/2024. It was submitted on 11/9/2024 that the verification was yet to be completed and as such sought for further time. Accordingly, the matter was fixed on 29/2024. It has been submitted by Mr. I. Botaku, the learned Standing Counsel of the PHE department, that till date, no verification has been completed. From the above, it prima facie appears that the order passed by this court have not been adhered to. Order dated 9/4, the directions passed in the order dated 9/4/2024 in WPC number 2147 of 2022 have not been adhered to. Under such circumstances, this court issues notice. Under such circumstances, this court therefore directs gives an opportunity to the respondent contemptor herein to explain as to why contempt proceedings should not be initiated against him. The list according. Yes, what is this?
Yes, Lordship, this is contempt petition, Lordship, order at page 11, Lordship, paragraph number 6. In this case, your Lordship was directed the contemptor respondent, the entire exercise shall be completed within a 4-month, your Lordship. But it has been not done by the respondent contempt. Lordship, at page 11.
P.R. Mohanto, kindly take instructions in this as to whether the order has been 10/1/2024 have been complied with. List this matter again on 21st of October 2024. In the meantime, this court have requested Ms. P.R. Mohanto, the learned Standing Counsel of the Revenue and Disaster Management Department, to apprise this court as to whether the order passed by this court dated 10/1/2024 in WPC number 88 of 2024 have been complied with or not. The registry shall show her name in the court list.
Item 5,
Lordship, this application is preferred by the Board of Directors.
Huh?
Board of Directors of Bhukatpara SS Limited. with a prayer of
Not
our
be issued to give retirement to the respondent from the post of the secretary as he crossed the age of 60. Our wife should not be issued to appoint a new secretary. And now you want an interim without hearing.
Lordship, kindly come to page 27,
What is this?
rule 19, Lordship.
An employee shall stand retired on attaining the age of 60 years. The date of retirement shall be the last date of so and so. So the secretary has to retire.
Lordship, you had already crossed the 60 years.
When? Whom have you approached? Have you approached anybody?
Kindly come to page 41.
The board of directors have requested. The board of directors have no power to remove the secretary.
Lordship, you kindly come to page 41, Lordship. The Board of Directors held a meeting on 2024, where they have made a representation on the proposal 5 to release the present secretary, Lordship. And on the basis of that, the representation they have sent to the Assistant Registrar of the Cooperative Society, Assam, Lordship. And till that,
Then he directs to maintain status quo.
the additional registrar of the cooperative society sent the letter to the joint registrar of the cooperative society, Tejpur, Lordship, to maintain the status quo.
That not to retire him.
Yes, Lordship.
Yes, what is this? Huh? Remove him. This is not done. His Aadhaar card is this. Where is the inquiry report? Now you want him to be removed.
The respondent number 6.
Who are you?
I'm the petitioner, along with me, other 8 board of members are there. Petitioner number 1, Lordship, I'm the president of the, I'm the president of the Bhagatpara SS Limited.
You are the committee. And all these 9 are there.
Sorry.
Out of 15. 15.
13.
You have how many members?
13, Lordship.
12 members. Consists of 13 members, out of which one is the chairman of the committee and 12 others are members. And there is the post of chair to manage the affairs of the secretary. It is because of this status quo passed by the additional. This has happened, no?
Yes, Lordship.
We have it before vacation. You instruct the issue notice making it returnable on 3rd of October 2024. Mr. S.K. Talukder appears on behalf of the respondent number 1 to 5 and accepts notice. Puस्तक. Extra copies of the writ petition be served upon her, them, during the course of the day. As regards the respondent number 6, the petitioner is directed to effect service by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. Puस्तक. The petitioners herein are aggrieved by the actions on the aggrieved in not retiring the respondent number 6 from the post of the secretary of the Bhagatpara SS Limited, Mongoldoy, in spite of the fact that the respondent number 6 have already crossed the 60 years. In support of that, the petitioners have enclosed the Aadhaar card of the respondent number 6, and from the same, it appears that as on date, it prima facie appears that as on date, the petitioner, the person's age, the respondent number 6 age would be more than 60 years. Full stop. The learned counsel appearing on behalf of the petitioner submit that it is on account of a communication issued on 13/8/2024 by the Additional Register of Cooperative Society. The respondent number 6 have not been removed as he had directed to maintain status quo until further orders. The petitioners further submitted that they have submitted a representation to the Register of the Cooperative Societies dated 23/8/2024, but the same have not been acted upon. It is under such circumstances the petitioners therefore have filed the petition. This court further the learned counsel appearing on behalf of the petitioner submitted that as the period of 60 years have already, as the respondent number 6 have already completed the period of 60 years, an interim order be passed to the effect that the respondent number 6 be debarred from functioning as the secretary. This court would not like to pass such an order in absence of without hearing the stand from the respondents. Mr. S.K. Talukdar is directed to apprise this court on the next state as to whether the respondent number 6 have already crossed 60 years and if so, whether the respondent number 6 can be permitted to continue in the post of the secretary. Yes, Mr. Borgia.
Now, if your lordship are the owner of a 6 kata, some chatak, my lord, and requisition authority, my lord, without considering that, my lord, without calculating our jira, they has proposed, my lord, to pay 54 lakhs, we did not receive, my lord.
Why?
My lord, they have not taken jirat and land also
They
out.
will take Zirat. They will give everything. If you are agreeing,
No,
why
but
you are
even
not
land also-
approaching under 3H5, 3G5? Why you not taking that money? Take that money under protest. Okay. You are not taking
Because
it.
out of 6 kata, my lord, they are showing, my lord, only 5 kata.
Whatever may be, they are taking 6 katas, how much money? If you have any problem as regards the compensation, why you are not going before the authority? That can be this and after.
Presentation, my lord,
Where?
from the authority.
Where?
That your lordship will see. uh, 49.
Huh?
Page 49 and 58, my lord. Lordship, kindly have a look, 58.
50?
8. They have duly received also. my lord.
Now award has been passed. The determination has been made.
No, my lord. Only I have been asked to take money, my lord. All the villagers they refused to take because the calculation they have done is not the exact, my lord. I am
How is it possible that you will be asked to take the money? Tell me, where is it? Where is the document?
document I do not have, my lord. I went
You are
RTI
saying
also,
that
RTI also, my lord, they did not get. Another representation, my lord, 49 also be seen, my lord. I asked
49 to whom? Executive engineer.
lordship, 49 and
What is all this thing?
49 to yeah, PWD.
How can I ask you, tell me, if this is so, if you have done it as to whether the compensation has been made?
According to the petitioner, compensation has not been made.
No, not paid to you, but
Right.
has the compensation been determined? Yes, Mr. Kala. Compensation has been determined? No.
Ultimately, he ought to have approached that under arbitrator.
No. He can approach the competent authority also, which he has approached as per 58.
He has mentioned it.
Paragraph?
That
All
is the
these
low point
provisions
I
are
quoted.
known to the petitioner, then also he is writing. Page.
Test 10, my lord.
It although the petitioner has been remanded or has confirmed, but yet the district commissioner, Kacha compensation confirmed only one.
In respect of 5 kata without keeping the market value of the land and Jirat amount not confined. Let them take instruction, my lord, what happened, whether the compensation exactly they have
This
made.
court is not there. Let me go there and become the Kala, then I'll do it.
Lord,
Don't come up with all this. For that, Mr. Burwa is there. He may have the same title, but that doesn't mean. No, if you did it so, then why didn't you submit a press application asking for reference? You'll get everything. How can this court tell me once it has been done, the act says the particular mode. You have written, in fact, you have quoted that provision. See,
all the,
you have quoted. Kindly see, page 12.
my lord, I have quoted all.
Very well. You quoted everything, but you have not adhered to that. Kindly come
Well-
to page 12, serial number 5.
My lord,
If the amount determined by the competent authority under subsection 1 or subsection 2 is not acceptable to either of the parties, the same shall, on an application by either of the parties, be determined by the arbitrator to be appointed by the central government. Then, or number C, such notice shall state the demand and before the competent at the time and place and to state the nature of it. Then you have the option.
my lord, they did not act upon, my lord, especially for the competition, if they had done, then otherwise.
Understood. Can this court pass an order today?
No, my lord, not.
Then who can pass the order?
Lordship,
Competent authority. I will therefore only direct that you appear before the competent authorities, file your representation properly, not in this type of manner, giving details how much should have been bid. And thereupon, the competent authority shall forward it for make a reference to the arbitrator and so on. That's it. Nothing more than that. Keeping these matters pending out here doesn't help.
my lord, if the arbitrator is not within the district, my lord, old man cannot go, my lord. If the
You are there, na?
arbitrator is somewhere.
You are there, na?
My lord.
So you want an arbitrator back at your place?
No, my lord, in the home district of the
He
petition.
did not go, na? These are many. You see, how this arbitration is being done under the National Highways Act is not in terms with, purely in terms with that. That is why there is one judgment also of the Supreme Court to that effect, where the question arose as to how it is to be done and all. And as to whether the question arose as to whether the central government can appoint in view of 12.5. The Supreme Court said that no, these things would not apply here because the central government here only will appoint. This is the mandate of that. So under such circumstances, here the arbitrator, what he does, he all this area, how he takes it. And then he passes one award for all this area. Isn't this? This is how he does. Because he doesn't have, there are 400 matters of one arbitration LA cases. How he can't pass H order like this? Okay, Lekhok. Deputy, I heard Mr. J.L. Bhumia,
J.I.
the learned counsel appearing on behalf of the petitioner. Huh?
J.I. my lord, not.
J.I. And Mr. S. Burua appears on behalf of the district, the Kala, appears on behalf of the respondent number 2, 4, 5, 6, 5, and 7. PWD anywhere to be seen? No PWD. Okay. Yeah, 5. And Mr. R.K. Talukdar appears for the respondent number 3. Any government of union? No. Taking into account the dispute involved in the instant petition, this court finds it is of the opinion that the matter requires to be disposed of at the motion stage itself. It is the case of the petitioners herein that the respondent authorities have acquired 5 kathas of land where it
10 lasa, 13 gondas. Compensation giving only page 58, man. Compensation giving only 5 kata.
No. Show me in that the section AR notice. Where is your land? Annexure 3?
Annexure 3, my lord, I have to see.
Huh?
Just check it.
Which one?
Annexure 3, my lord, original I have given, my lord, by in persons to the annexure 3 they have taken.
Which plot of land? How much land it has been shown in there?
So one, I'll check it up, my lord, just now.
Here, 0.335.
That is the, they are saying, my lord, this is not kata, my lord, that is the hectares they have called.
David. So it is the case of the petitioners that the petitioners who are the petitioner or petitioners, petitioner who is the owner of a plot of land measuring 6 katha 10 chotok 13 gondas. So in the case of the petitioner is the owner of a plot of land measuring 6 katha 10 chotok 13 gondas covered by Dag number 7 of Patta number 3, Mozar Rangpur Part 2, Pargana Barakpur in the district of Kachar, Assam. Full stop. It is the specific case of the petitioner that out of the said land,
I think building and wall also.
out of the said land, 0.0335 hectares of land have been acquired under the National Highways Act 1956. Full stop. It is the further case of the petitioner that in the said land, the petitioner has a two-storied building. Two-storied?
Yes.
Has a
So,
two-storied building.
that building consists of 4 floors.
How many floors?
4.
The
Page
has a-
58 is it.
has a building situated which is of 4 floors.
Out of
Full
which
stop.
ground.
However, while computing the compensation, the competent authority have paid an inadequate compensation without taking into account section 3G7 of the National Highways Act 1956, read with section 26 to 28 of the Right to Fair Hai Lamba Ekon Ekkono Naam to Didibo, 2013. Full stop. The learned counsel for the petitioner further submitted that the petitioner had submitted a representation also to the competent authority on 29/7/2024 for making a proper assessment of the valuation of the land compensation and the jirat. However, the same have not been taken into account. It is under such circumstances the petitioner has therefore approached this court by filing the instant writ petition. This court, having taken note of the provisions of the Act of 1956, is of the opinion that if the petitioner is agreed with the inadequacy of the compensation, the petitioner has the option of approaching the competent authorities seeking a reference to the arbitrator in terms with section 3G5 of the Act of 1956. Further to that, this court would not be in a position, further to that, once the determination has already been done by the competent authority, the same can only be modified or interfered with in terms with section 3G of the National Highways Act 1950 of the Act of 1956. Under such circumstances, this court therefore disposes of the instant writ petition, thereby granting the liberty to the petitioner to submit a fresh application before the competent authority. That would be the respondent number 5. And thereby, whereby the petitioner may seek a reference to the arbitration. Full stop. In terms with section 3G5 of the Act of 1956. Full stop. The Mr. J.I. Bolbhuya, the learned counsel appearing on behalf of the petitioner, submits that the petitioner shall do the same forthwith, shall carry out the said exercise forthwith, but submitted that the competent authority should immediately refer the claim of the petitioner to the arbitration. This court directs the respondent number 5 in the event the petitioner submits the application in terms with section 3G5, the same be referred to the arbitration who have been duly appointed by the central government. And forthwith and not later than 20 days from the date of such application being filed.
And not one thing to be included, my lord, where your lordship dictated, my lord, land road flow, including boundary wall of 15 feet.
Whatever you want. You see, you see the judgment while preparing that if you do it. 2022 15 SCC page 1. Have a look at it. Yes. Yes, what is this? Shillong matter. What is Shillong doing here?
This is a Nehru Park Church, These petitioners were the members of the pastorate committee. They, since the posting of the new presbyter, they have been prohibited from attending the church services. For which, I have given a small note, For the court.
Who is doing that? Christchurch here?
Here. This committee members, when new priests came, they have been offering their prayer for last 30, 40 years or more, but one presbyter has been, I've given a small note on they have a rule, they have an act, and small note I have given that how presbyter committees are formed. What happens when indiscipline is caused there.
Now, what do you want?
Now, my lord, your notice has to go, and your lordship, I'll pray for fixing a date, my lord, for the purpose of considering the interim prayer. Because interim prayer, my lord, two aspects. They should be allowed to offer their prayer. Number two, my lord.
You have submitted the representation to whom?
Representation to the diocese and also to the synod. Diocese and these are the courts. Your lordship goes to page 146.
These are courts.
There are three courts. One is my lord court of pastorate, other is diocese, and the other is my lord court of synod. So we cannot go to the pastorate because this is a presbyter.
Wait. Constitution means what?
They have made for the Church of North India.
Hmm.
First, your lordship will kindly see page 46.
Why are you bringing the Union of India and the Commissioner of Police?
The land belongs to defense. Land belongs to defense.
How does it relevant? It is a
Relevant,
dispute between
but-
you and the private individual.
Yes, but defense we have brought it because the land ultimately belongs to defense. Your lordship.
Now, what do you have to, does anybody have any dispute as regards
Nothing,
the
nothing,
land?
nothing.
Then why how a writ petition
I
will be
can-
maintainable?
This petition is maintainable with the Article 25, and I have given three judgments.
25 vis-a-vis against who?
Vis-a-vis against the private bodies because they are discharging my lord public function. My lord, offering prayer is covered by Article 40.
Isn't it a dispute between you and them? If that is so, how it has any relation with public functions?
Inside the church where we are praying for last 30, 40 years.
my lord, that
It's a private dispute.
not private dispute, and that hits my lord, that hits my lord, Article 25 of the Constitution. Against the
Article
management of
25
the
is
church.
against the state. Against the state, but state has nothing to do with it.
State has got nothing to do, my lord.
Sir, it is a purely private dispute. Why you are not going there?
No, Article
Civil court.
25, my lord, of the Article 25, the Constitution of India, it gives me right. My lord, your lordship will kindly remember.
Right against
Sabarmal
who?
case. Right against any person, only if
So
it's
let us
Kamakhya, my
see
lord,
Article 25, where does it say
Yes.
right against who?
which says, my lord, Sabarmala case, what has happened?
Sabarmala
person-
case is against the authority concerned. It is very true.
No, because there was a practice going on, not allowing this 10 to 50 years of the women to offer their prayer. So somebody filed a
Subject to
case.
public morality, order, morality or health or to other provisions of this part, all persons are equally entitled to freedom of conscience and the right freely to profess, practice and measure. Nothing in this annexure shall affect the operation of any existing law, when the state from making it.
Supposing, my lord, in any temple or in for Lord Kamakhya also, my lord, if I am prohibited from entering, suddenly, my lord, where I have been going for last 25 years, now they say, no, you cannot come. So that will not infringe my lord, that Article 25. Here also what has happened, my lord, 30, 40 years, I have been offering my lord, prayer there. We have a committee. When you bring a presbyter, my lord, you are supposed to take my consent or our consent.
Let us see whether the Sabrimala matters arise from a repetition.
I've given a committee.
Huh?
I've given a small note, that 3 page. Given.
Yes.
3 cases are given, there are plenty of cases are there when public duties are there, even against the bank. BCCI case is there. I've given even the charge of South India. Also,
No. That is a different thing. BCCI,
Public duty,
let us
public
take note of BCCI judgment is a case where it's initially started with television rights,
yes,
where they have done certain illegal, means they have not given it properly, they have done some illegalities, or it started with exactly to say that they initially the highest bidder was G, but they gave it to Star. And when that happened, G filed the writ petition in the Bombay High Court. While the matter was pending, they cancelled the entire tender process. Against that, the matter was challenged. Then the issue arose as to whether a writ would lie against them. But telecasting these rights has been held that they would not be a state, but they would be amenable under Article 22 to
it
6.
is amenable because my lord court says when the public.
But these
duties
are
are
not public functions.
Public function, my lord,
Vis-a-vis you.
is my great right, my lord, my right of offering prayer. Lordship will kindly see that, another judgment I have given, the Bride Joseph versus Church of South India.
No,
When
now
the
tell
court
me
said-
that this matter, Sabrimala matter is this Indian young lawyers.
Yes,
Does it start from the year, from a writ petition?
It started from the petition on
We
the
will look into it.
paragraph
Sabrimala.
97, but it says,
Sabrimala,
paragraph 97. And your lordship will kindly the Church of South India. That is also my lord, against the church.
Sabrimala started out. The irony that nurtures in any relationship with the creator is see, kindly see page 72 of the judgment in Sabrimala. Having stated so, we will focus on the factual score. The instant writ petition prepared under 32 of the Constitution 6 issuance of directions against the government of Kerala. Devarsam Board of Travancore, Chief so-and-so of Sabrimala Temple and the District Magistrate to ensure entry of so-and-so. Are you asking that this court should, they're asking the police to ensure you?
Police to ensure them, my lord.
This is not your
I-
case. How do you therefore,
Ensure, my lord, we went to deputy commissioner. Deputy commissioner tried to.
Deputy Commissioner is not a party here?
We, commissioner of police is a party.
Because you see, the Sabrimala is under a trust where the government officials, everybody are there.
The other case I have given, the Bright Joseph versus Charles of South India. There your lordship will see paragraph 21, 23, and 24.
Where?
There. Matter, these questions your lordship will leave it open. It will be discussed at the time of hearing of the matter. Maintainability, it will remain open, my lord. Your lordship, at this stage, my lord, issue notice for the purpose of, my lord, deciding whether, my lord, we have a right to pray or not. We are important committees of the church. Pastorate committee is an important committee, my lord. They are elected members. They, because education and all, my lord, education hospital, they are doing, they had that. Support said, my lord, Article 226 will go. Otherwise, my lord, public duties means, my lord, in any mandir, my lord, they are doing public duties only, my lord. Publics are going there. They're making, they're offering their prayer.
Understood, that is understood, but while offering the prayer, if they do something,
No, if while offering, my lord, supposing, my lord, in this case, what has happened? In this case, a presbyter has been brought who has acted against the, my lord, all norms of the service. So therefore, they have revolted, my lord.
no, what
Yes,
are
it
you
is. You
asking?
are
Let
not
us see,
accepting.
directing and commanding the response number 1 to issue appropriate notification as per Rule 30 to hand over the search control of the area to the congregation and to allow the petitioners to conduct the services. Okay. Okay, issue notice making it returnable on when? December?
November last,
Just before Christmas?
for Christmas.
Before lordship, issues notice, may I take your lordship to Annexure 10, that is the FI which they have been lost. This is only with regard to
Annexure 10.
three private individuals who have stopped them and obstructed them from entering the church. There was nothing said as regard to society who was managing.
I given representation, that is at
So
page
this is
89.
this is the FIR.
FIR I have
this is the
given.
FIR.
During
So
the
the FIR
obstruction,
doesn't
one
state
of the
anything.
senior members were also
That is the
pushed demand and.
start of the issue, man.
Anyway.
This is out and out of private dispute.
It is. No, what he is asking for is one relief. That is against respondent number 1, that notification is to be issued. So I keep the area open. I'll keep this particular maintainability open in spite of issuance notice. Issue notice making it returnable on 2nd of December 2024.
2nd of December.
It's a holy month for you out here. 2nd of December 2024. Union? No union. You appear for respond number 11.
Yes, only left.
So respond number, Mr. S. Buru appears for respond number 11. Full stop. Extra copy of the writ petition is served upon him. As regards the respondent numbers 1 to 10, the petitioner is directed to take steps by way of registered as well as usual. Full stop. Within 3 days. Full stop. It is the case of the petitioner hearing that the petitioners that the present committee
Then presbyter.
presbyter.
We are the pastorate committee, but because of the
You are
pastorate.
not the pastor, you are only one.
Not only, we have said we are the secretary.
You are
Yeah.
only one petitioner.
We are the secretary and we are representing 87 persons. We have given the names of the 87 persons.
Is this a PIL? Not a PIL.
Not the PL.
Then?
Passionate secretary of.
Here only one person is appearing.
Yes, we have given that we are representing the names, 87 persons.
Then,
Please,
then obviously, how can you represent for others? There has to be a PIL.
PL, let it come to a PL because our rights are involved. We are the members of the.
Again, you are coming to our petitioner is only one.
Petitioner is number one.
So
but
we
it
only
stated-
consider as the petitioner. It is the case of the petitioner herein is that the petitioner have been not permitted to pray in the Christchurch, Guwahati congregation by the respondent number who? By the private respondents,
Yes, 7.
numbers 9 and 10. And thereby affecting the petitioner's rights under Article 25 of the Constitution. The petitioner have also sought for a writ of mandamus seeking directions upon the respondent number 1 to issue notification in terms with Rule 30 of the Indian Church statutory rules. The respondents are directed to bring on record their stand by filing their affidavit. Mr. B.T. Das, the learned senior counsel, submitted that the petitioner would insist upon the interim prayer, thereby to allow the petitioner to conduct the services of Christchurch, Guwahati by the members of the Pastorate Committee of Christchurch, Guwahati without the interference of the respondent number 9 and 10. It is the opinion of this court that such an interim prayer cannot be granted without hearing the respondents. Accordingly, this court defers the consideration of the interim prayer till the next date. This court further observes that although this court had issued notice, the maintainability of the writ petition is kept open.
Right.
Yes, we may require it for the next time if I am not sitting.
Your lordship will.
If I am not sitting, you may
your-
not require.
your Lordship will decide this matter.
I think ready with it.
Will be
I'm coming this. Of a notification under Section 6 of the Act of 1964. It is the specific case of the petitioner that the petitioner had not been paid the compensation in spite of the fact that the petitioner have on various occasions approached the concerned respondent authorities. Under such circumstances, the learned counsel appearing on behalf of the petitioner submits that the acquiring of the land of the petitioner without payment of compensation amounts to violation of Article 300A of the Constitution. In addition to that, the petitioner further submits that it was that the requisition cost, the requisition amount to which the petitioner is entitled to till the acquisitions have been done in respect to the lands in question have also not been paid. So Mr. B. Chaudhary as well as Mr. S. Bulwer are both directed to apprise this court as to what is the amount of compensation which the petitioner is entitled to in respect to the acquisition of the 4 kata 5 lectures of land by the notification dated 14/12/2022 in LA case number 35/2022, and why the said amount have not been paid till date. Full stop. In addition to that, the respondent authorities are also directed to apprise this court after making due assessment as to how much the petitioner would be entitled towards the requisition of the petitioner's land prior to the requisition of the petitioner's land from 31/5/2018 till the lands were acquisition in acquisition. List accordingly.
Item 50,
Yes, what is this?
find the regulatory application,
You filed substitution.
substitution.
Have you filed or not?
Yes, we have filed.
Well,
We have filed in the last day.
who died?
That's
Who died?
petitioner. Petitioner.
Well,
They died on 8/5/2022. You know, sir, during the day.
only one legal error.
on-
How do you say so?
We have been informed over.
Okay. এই তিনিখন application লিখিব হা এই তিনিখন
What else, sir?
The above 3 applications have been filed seeking condonation of delay, setting aside of the abatement, as well as for substitution of the legal representative of the petitioner who expired on
8/5/2022.
8/5/2022. Taking into account that the instant proceedings have been filed under Article 2 to 6 of the Constitution, the question of application of the Code of Civil Procedures strictly would not apply, taking into account Section 141 of the Code of Civil Procedure 1908. Be that as it may, this court is of the opinion that taking into account the grounds assigned in filing the instant application, this court does not find that there has been any delay or laches. Moreover, the right of the petitioner, the legal representatives, survives upon the death of the petitioner in respect to the cause of action, which is the subject matter of the instant petition. Accordingly, this court disposes of the 3 applications, thereby substituting the applicant herein as against the name of the petitioner. The counsel for the petitioner is directed to file a fresh memo of parties before the registry of this court, and within 3 days from today. And on the basis of the same and the instant order so passed, the registry of this court shall make necessary changes in the cause title and also update the same in the CIS. IA stands disposed. Yes, you do that. Thereafter, we'll take this.
Fifty-one.
Yes, Mr. Advocate General, what do you propose?
My proposition is very clear. They have added so many petitioners in the same petition. Let them file an individual application to the deputy commissioner. He will examine if they are prior to 1950s, then they have to prove with him before him. He will examine, will give them the opportunity to prove their case individually.
I
Let
think that is a
individual-
better. option.
That is the only option, Lord. Sir. We do not want to do anything illegal. Whatever
No, I
is there.
understand that you are also pressurized in view of the division bench order.
there.
There is there, but the thing also that in these division bench matters, all the people who are there in the tribal areas are not parties. They're not parties. So the division bench has been passing orders only hearing the state or some parts, one or two. So therefore, these people, if they have any right over the land, they can very well assert it
Yes.
by filing an application. But to go ahead and doing this by 3 days, it would be next to impossible.
The thing is that they are not available also. Individual notice also could not be given. Nobody is staying there.
No, we are available, my lord, in our residence.
Nowadays.
No, my lord, since 23, my lord, the descendants and the petitioners are available.
Okay, how many matters are there?
My lord, only 3 petitions today, my lord. In my petitions,
Which are the matters?
item 51, 52, and 55. Petitioner number.
Executive matter due.
But then this notice is required to be set aside.
No, this notice remains out there, but
Fine.
you will be going there.
Fine.
But Mr. Advocate, whatever may be, why don't you issue a notice
Press
to,
notice.
they are asking them to have any claims and then they say, I think that, don't you think that will be better?
It's a re-
No, they will do it. But
Lordship
otherwise,
may-
also-
Lordship may restrict this matter to the writ petitioners. Let whoever is active, they can come individually.
because every time they coming with petitions, because I don't want these courts should be flooded with
No,
this
no.
type of litigations.
But one
That
thing
this
is-
court should pass an order and then this happens. Because if there is a pattadar, you are required to follow 165(3)(a). See, 165(3)(a), this process which you have initiated cannot be there in respect to if a person comes within the ambit of 165.
The documents, Lordship. Now, prima facie, it is very clear that most of them got their Jamabadis in 1960s, 70s, like that. So, on the face of
But
it,
then
Lordship,
also they are pattadars. No?
Pattadars,
So
still, Lordship,
there, when the act itself mandates that if there is a person who is a trespasser, you don't give notice, you just throw him out. If he's an exonia patta, there's a difference. But when he's a pattada, periodic patta holder, then you give him 1 month notice, asking him to come and whatever may be. Then how, if you do this by giving them one fine day, only 3 days notice, then to take over, how do you take care of that situation? This is the point that as regards the petitioners, I'm directing them. But think about it, you are the advocate general, Baki 18 you have how many writ
My
petitions?
lord, we have in 51, my lord, 22, 23, my lord.
Huh?
In item number 51, my lord,
51,
Uh,
52,
52 is my case, my lord.
and 51 is whose?
51 is ours, my lord.
51, 52, and 55.
55 is my learned friend.
These are the 3 writ
Only 3 petitions.
Petitions on board today.
let them file an application.
I'll dispose it of.
Let them file an, I want disposal only, Lordship. Let them file an application within 7 days before the deputy commissioner, and he will give them reasonable
Along with
opportunity.
all the documents they will submit in the,
And we take a call in 3 weeks' time,
no, whatever, that is your, how much time you take.
Lords.
They will submit the documents
Yes.
and you give them a date of
Reasonable
hearing
hearing.
and thereupon they
Lords.
decide.
press notice or not?
No notice, Lordship.
You are given 7
Fine.
days, I'll give it.
Fine.
I am giving you the notice.
Hello.
They will individually approach the deputy.
But
With all
you do it
parties, sir.
individually.
Yes, that can.
Heard Mr. A.R. Bhuya, the learned counsel appearing on behalf of the petitioners in WPC number 4818 oblique 2024 and 4820 oblique 2024. And Mr. N. Bulwa appearing on behalf of the petitioner in WPC number 4840 oblique 2024. Question. I've also heard Mr. D. Saikia, the learned advocate general, assisted by Mr. R. Vakidari, the learned standing counsel for the revenue department, who appears on behalf of the state respondents. First, in the three petitions, the petitioners have assailed the notice dated an undated notice,
Dated
a notice dated 13/9/2024, issued by the circle officer, Punapur Revenue Circle, Kamrup Metro District, whereby the lands mentioned in the said notice, that is Miadi Patta number 12202 and Exonia Patta number 1287, have been held to be under unauthorized and illegal possession of the people other than the protected class as per Chapter 10 of the Assam Land and Revenue Regulation 1886, for short, the regulation. Under such circumstances, all the inhabitants of the said lands mentioned in the notice were directed to vacate the lands within 3 days of service of the notice. The petitioners herein claim that they have rights over the lands under their possession, wherein they were initially issued annual pattas in the year 1923.
3-28.
That's 28. And thereupon have been issued periodic pattas. It is the case of the petitioners that as their rights, they had rights over the land even prior to, well, that document you gave it yesterday, Simon?
Yes, sir, in Milord,
that document, na,
yes, sir.
making it that schedule. No, that document you gave yesterday, na? That order, 1950 order you gave it, na? It was submitted. It is the case of the petitioner that their rights that they had rights over the land even before the lands were declared to fall under Chapter 10 of the regulation by the government notification number RD.74/46/172 dated 27/2/1950. And as such, the summary manner in which the respondent authorities have resorted to evict the petitioners who have been having rights over the land almost for a century, 100 years, is absolutely arbitrary, unreasonable, as well as in violation of the provisions of section 165(3) of the regulation. First, anything else?
Not only
It is also further relevant to take note of that in the instant writ proceedings, various documents have been enclosed to show that the petitioners have rights over the land as contended by the learned counsel for the parties, for the petitioners. Stop. Mr. D. Xavier, the learned Advocate General, per contra, submitted that in terms with the notification number 27, dated 27/2/1950, the Revenue and Settlement Department of the Government of Assam under the orders of the Governor of Assam had constituted the tribal belt in terms with Chapter 10 of the regulation. The learned Advocate General further submitted that Chapter 10 of the regulation is a very special chapter in order to protect certain classes who, on account of their primitive conditions and lack of education or material advantages, are incapable of looking after their welfare insofar as such welfare depends upon their having sufficient land for their maintenance. The learned Advocate General submitted that in terms of section 164A and 164B, stringent conditions have been imposed, keeping the legislative enactment for protection of these backward classes The learned Advocate General further submitted that once the lands have been notified in terms with chapter 10, there cannot be any acquisition by any other class other than those classes falling under chapter 10 of the regulations. He therefore submitted that if the petitioners have any rights accrued prior to 27/2/1950, they can very well show it, place it before the Deputy Commissioner, Kamrup Metro, by submitting a representation, and the said aspect would be duly considered. First, in addition to that, the learned Advocate General had also referred to the order passed by this court, by the division bench of this court, dated 9/12/2019, in PIL number 78/2018, wherein the division bench, by way of a continuing mandamus, have been directing the state government, including the district administration, to take effective steps for protection of the lands falling under chapter 10 of the regulations.
One more, the Supreme Court's order also in the, whatever Lordship is proposing, identical order of the Supreme Court also is.
The learned Advocate General further submitted that in pursuance to the order passed by the division bench of this court, dated 9/12/2019, in PIL number 78/2012, the matter was an appeal, a special leave to appeal was filed before the Supreme Court, bearing SLP C number 2121/2020. First, the Supreme Court, by an order dated 3/2/2020, had observed that the order dated 9/12/2019 merely was a direction upon the Deputy Commissioner to proceed against the unauthorized occupants in accordance with law, which presupposes that the Deputy Commissioners must examine the claim of each occupant on case-to-case basis, and after recording satisfaction in the light of evidence produced before him, proceed to pass appropriate orders by law. The learned Advocate General therefore submitted that if the petitioners submit their representations along with the necessary supporting documents, the Deputy Commissioner, Kamrup Metro, shall duly consider the same and also provide an opportunity of hearing. Full stop. Taking into account the above, no, full stop. In the backdrop of the above submissions, this court have duly given an anxious consideration to the subject matter involved, to the challenge so made to the impugned notice. Full stop. And the submissions so made by the learned counsels for the parties. Full stop. It is seen from a perusal of chapter 10 of the regulations that by section 60, an obligation has been cast upon the state government to adopt such measures as it deems fit for protection of those classes who, on account of their primitive conditions and lack of education or material advantages, are incapable of looking after their welfare insofar as such welfare depends upon having sufficient lands for the maintenance. In terms with section 161, a power has been conferred upon the state government to constitute compact areas in regions predominantly peopled by classes of people notified under the provisions of subsection 2 of section 160 in belts or blocks. It is seen that the notification dated 27 to 1950 has been issued in exercise of the powers under section 161 of the regulations. Section 163 of the regulation stipulates the manner of disposal of land for the purpose of cultivations. And section 164 stipulates about the rights of settlement holders and landholders. In terms of section 164, there is a bar of acquisition in a belt or block unless such a person does not belong to a class of people notified under section 160 or to a person who is not a permanent resident in that belt or block. Section 164A and section 164B were inserted by the amendments carried out in 1981 and 1990, respectively, in order to make the chapter 10, the bar contained in chapter 10, more effective. Section 165 stipulates the manner in which the ejectment and eviction is to be carried out. In terms with section 165, it stipulates three different circumstances where, as it stipulates the manner when such lands the manner then in terms of section 165, the manner, the treatment, how the treatment in terms of section 165, it is in section 165 of the regulations and besides the treatment to be given to different classes of persons who are in occupation of lands falling under chapter 10. The first of such class is a person occupying without authority. The second is those who are annually settled. And third, those who have been periodically settled. At this stage, this court also finds it relevant to correlate section 165(2) with section 164(1), which categorically stipulates that a settlement holder other than a landholder shall have no right in the land held by him beyond such as expressed in his settlement lease. It is further seen that in terms of subsection 3 of section 165, a different treatment is to be given to those people who have been periodically settled. This court have also given in sanctions consideration to the submissions so made by the learned Advocate General, which seems to be in consonance to the directions so passed by the Supreme Court in its order dated 3/2/2020. The said order is reproduced hereunder. Permission to file OPRA. Pending applications, if any, stands disposed. From the above order, it is clear that that the Supreme Court observed that the Deputy Commissioner must examine the claim of each occupant on case-to-case basis, and after recording satisfaction in the light of evidence produced before him, proceed to pass appropriate orders as per law. The Supreme Court further observed that if that order is adverse to the occupants, the Deputy Commissioner must give reasonable time to the occupant to take recourse to appropriate remedy as may be permissible in law. And the Deputy Commissioner it was also observed that the Deputy Commissioner shall decide the proceedings uninfluenced by any of the observations made by the High Court in the order dated 19/2/2019.
12.
1912. 9/12. In that view of the matter, this court is of the opinion that the interest of justice would be met if the petitioners herein are granted the liberty to submit their representations submit their respective representations. Within 27
Can it be on 30 some petitioners may have to
30.
Yes, no difficulty.
Within 39/2024, before the, you have any office means deputy commissioner?
They
Because
will
you,
come. There's a
they-
section is there.
Huh?
They will know, Lordship.
they will- Before the office of the deputy commissioner,
Yes.
Kamrup Metro, along with all their supporting documents. who's- The deputy commissioner, thereupon, the deputy commissioner, Kamrup Metro, is further directed thereupon to decide the claim of the petitioners by giving them an opportunity of hearing. Who's- Thereupon, the deputy commissioner shall pass such orders as per the provisions of law.
Individual order should be passed.
Shall pass individual orders, because individually application. Shall pass individual applications in accordance with law. Full stop. The deputy commissioner shall also keep in mind the order, the directions passed by the Supreme Court dated 3/2/2020 as quoted here in above. With the above, the instant commission stands.
Take a decision, right?
No, we are not going to do lots.
May not be. That observation, my lord,
And this is in respect of the writ petitioner.
that may be recorded, my lord, otherwise. We're
No,
applying.
we will not play with the honorable court.
No, there is a direction of the Supreme Court is given.
My lord, that is
So,
correct.
yeah. So,
That notice is there, my lord, it has not been interpreted.
for the sake of clarity, this court observes that till the deputy commissioner decides the applications, the representations, which if filed within the time stipulated here in above, no adverse actions be taken. Against the petitions,
That line may not be. Certain.
till they are decided.
Will be decided.
Against the
That will again give a different color in the overall society. So we are submitting before them, we will not take any action against the writ petition. It is in ours, we have considered basically.
That
That
submission.
last line may not be.
Mr. Anagari, Mr. The counsels appearing on behalf of the petitioner submitted that there be certain orders are required to be passed to the effect that the petitioners may not be evicted till the disposal of the applications, representations so submitted by the deputy commissioner. Mr. D. Shaikia, the learned advocate general, submits on instructions,
Yes, on this.
that gives an undertaking to that effect that no action would be taken against the petitioner till their representations are disposed of. Are duly disposed of.
My lord, and only the notice date in item number 52 is 14/9. One is
Huh?
13/9. The MPO notice, my lord, which has been recorded by my lord, is 13/9. In item number 51, it is 13/9, and item number 52, it is 14/9.
And yours? 13/9 and 14/9.
Highly
Public will,
Highly
huh, 13/9. Otherwise, keeping these matters state, not good. Or you will treat me like a civil court looking into these people.
We do not want that, Lord.
So let all these be decided by your people. I have nothing. But this being the judgment of the Supreme Court, don't you think about that notice which you have issued? Because that notice, you are just giving 3 days.
Respect of some petitioners there. Individually, people, some BTC area people went there. The Supreme Court.
These are BTC area. No, these are Kamrup.
That case.
Oh.
So that is in respect of those petitioners. It was not in rem, it was in person. Highly obliged.
Highly obliged.
Yes, what is this?
Made with the lordship, my lord, we are against the notice issued under Rule 18 from 76 onwards, page 76 onwards. Previously, my lord, there was direction from this court till our representation for settlement is not disposed of, we may not be evicted. But still then, my lord, the notices have been issued saying that they will take recourse to 18(3). If
What
by-
land is this?
Huh?
These are many times these matters are going on. What
My lord, this is in Ulubari Moja near this, my lord, Ulubari. This is Ulubari near Ulubari, khas land. my lord. Because previously annual patta land, then it was converted into a khas land.
Your land?
My lord.
It has been made periodic patta.
No, but it was annual patta, then it was been declared khas. So it was khas and we wanted for settlement,
It was annual patta of somebody else.
somebody else. Then my
So
lord,
you
we
have been occupying them.
occupying because it's a
So
big-
they cancelled the annual patta and made it khas.
Khas. And now, my lord, we have prayed for settlement a long time back. It was in, my lord, 2001. Then there was an eviction notice. I approached this court, court said, till their representation is disposed of, don't. sell
Where?
it." That order is at page 62.
Page 62.
And earlier, my representation was at page 52.
How many people are here?
My lord, here the 20 petitioners are in, 17, my lord.
It's 17. How much is the land?
My lord, in notice it is given, my lord, 8 bighas.
Where?
At page 91, you also will find from 76 onwards, they have stated 8 bighas, 9 lectures, Jomi Bedapal Koreas. Page 91, you also Sarkari land. My prayer is
All
that
is one dog.
in one dak. My only prayer is this, my lord, if they can, we'll file a representation again, my lord. They claim our bona fide claim and right, my lord, and they will dispose of in accordance with law. We have our assessment of the land, we have our electricity, we have done everything, my lord. 2-3 decades we are sitting over the land, my lord.
Yes, Mr.
They came into occupation of the part and parcel of land by way of purchasing possessory rights initially. And they have, my lord, enclosed the copy of the Sikha. Then, my lord,
What does the Sita say?
Sikha lordship will find at page 26. Page 26 of the writ petition.
What do you have there? House?
My lord, house.
You made it without
1975,
permission.
86 on
Lord,
Blueberry
We have
Mundar.
our assessment also, your lordship will find
Assessment, forget about assessment. You made it without permission.
some type.
Well, then demolishing that house is no problem.
Only my prayer is on. My only prayer is on the basis of Salahuddin Marat, paragraph 29 to 31. That much, that bona fide claim they can dispose of by filing a representation.
But do you have the right to get possession of that land itself? Because you see, this is a very valuable land. Very-
Prior to that, during annual.
Therefore, it was annual patta land. So naturally, my lord, they have purchased possessory right. The moment it was converted into khas land, made government khas land, perhaps there is nothing on record in this petition, subject to what is saying, that it has been put to challenge.
Huh?
It was put to challenge. The action of the government hereby, my lord, declassifying the Exana Patta land and making it government land, perhaps have not been challenged by them. One aspect of the matter, so they have waived the moment, when one can understand, my lord, there is a khas land, I come into occupation, the moment I come into occupation of the, I mean wrongful occupation, albeit, my lord, my lord, dictum pronounced in Salahuddin. One. Second, if this is the second situation where they were in occupation, it was the classification of the land got changed from, my lord, Exona to, from the
Khas.
Exona to
No,
khas.
Exona was given to somebody else.
So therefore, they have only purchased the possessory right.
No, maybe they have done possessory right, they have purchased, it's a different thing. I'm not on that. But the fact, whatever may be, they are in possession.
They are in possession, but the fact
They had submitted applications for settlement. There is an order that till you dispose of the yard, don't disturb. then how, what are you not, why you are not taking steps on disposing of that application, or have you lost it?
That is on facts, my lord.
No, that is the most important. Let us not go on that.
Yes.
Because how do you take care
No,
of this
because why-
order, this
why-
court to say that I'll shut my eyes out there and not look into Justice Ansari's order?
Everything is there. I am not, my lord, because I am a one step ahead. My lord, if they find a representation, what they will do, they will be setting up their bona fide claim. In setting up the bona fide claim, that aspect of the matter will come, whether they have waived their right, my lord,
For
at
what?
that point of time.
No, there's no waiver.
So
Where
whether-
is the waiver? They purchased it, let us assume that they purchased it from that Exonia owner. And they cancel this Exonia. But that no rights will flow there, because it's an unregistered document. That document therefore is known as, let us not here, but they are in possession, they have submitted an application, and you have not done anything all this while. You may have issued, kept on issuing notice after notice and notice. Now, tell me, if it is under 18.3, how do you evict them?
Perhaps, my lord, it is notice, my lord.
18.3 is the document where which you make people fear that I am going to file a suit.
No, therefore, legal steps will be taken. My lord, I am reading the vernacular. Assam Raja, Bhumi Raja Odhiniyam 1886, 18.3 নম্বর ধারা অনুযায়ী আইনগতভাবে ব্যবস্থা গ্রহণ করা হয়েছে। Read on that. I have to fairly admit.
18.2 gives you the power to evict. 18.3, the moment you come, therefore you see 18.3, 18.6 or 18.5. If a person is in illegal possession, in spite of a notice, he is liable for penalty. So 18.3, the moment you go to 18.3, the concept of evicting, you evict them only by due process.
Yes, 18.3.
18.2, you can exercise your power of summary. 18.3 is not summary, therefore it is said any other land.
My humble submission, in fact, it was.
But 18.2 has become redundant in view of
18.3 had
18.2.
মানে post Salakuddin, 18.3 has become redundant, but so far as my lord, if we মানে throw a my lord,
And
light-
what is there in the name? A rose is always a
No,
rose.
no, my lord, there is a reason.
It is
because-
18.2 is the power.
No, 18.2 is the power, but my lord, continuing with 18.3 has a reason, my lord, vis-a-vis rule 16. My lord, rule 16. Because rule 16, my lord, until it says, my lord, that until a formal lease is, my lord, granted, issued, the deputy commissioner may give a written permission. That till it is issued, for the timing you stay here. My submission will be, my lord, 18.3 will be attracted in those circumstances. 7, except that, my lord, there is no situation which can be envisaged, my lord, to be brought into the fold of 18.3. My respectful submission.
No,
subject
that
to
was
lordship's
what
correction.
the Advocate General submitted there.
Yes,
It is only in respect of allotment.
allotment, therefore, allotment is always conditional.
It is only in the aspect of 18 allotment you can now do. Because earlier you should have amended 18.3 accordingly when you came out. Now therefore only land remains is allotment. So 18.3 would not come in. But whatever may be, how do you take care that unless you dispose of their
No, no,
representation?
it's on facts, my lord, I cannot improve my case.
So why you are not disposing it on?
Yeah, but my lord, the best way will be.
Because
my
the
lord,
moment you reject it, then you may show that yes, this is a land we want it for some infrastructure reason which may have a better public interest than them. You can very well give them some other land somewhere. Look, it is after all a valuable land in the heart of the city.
So therefore, my lord,
And that too, he only has small houses, as he said, without permission.
of this
No,
application.
this can't be disposed of. If I dispose it of, it will be more dangerous for you.
Finding a place, paying a face representation. Yes,
No representation business. Here the representation question doesn't come because of the fact that there is already an order passed by the
Then why
court
not-
that without disposal. So you take it up out there. Once you take it up, then another fresh call of action will arise. I hope you understand. I'm in favor of your statement.
Because on facts, my lord, then my lord, lordship will have to display short notice, my lord, on facts, will have to
What
find
is
an affidavit.
only, Puja, nobody should disturb it.
That is the predicament.
Yeah?
That is the predicament.
Puja, you should not disturb. Okay, we'll take it, pass the order to.
My lord.
Puja, no disturbance.
I don't know how, whether they will be celebrating Puja, my lord, or
Why?
petitioners.
They have the business. Huh?
Yes.
Be taken up today due to some my personal difficulties.
Well,
At any date, my lord, I have no objection.
request to the learned council for the petition of applicant adjourned to be listed after vacations. Is there in interim order?
For judgment, item 1 to 11 belong to Guima bench.
The appointments which have been challenged in the instant writ petitions, that is 935 post of constables who were appointed during the period from January 2018 to October 2019 by the state of Nagaland, without advertisement, are all set aside and quashed. The appointment orders enclosed as annexures referred to in paragraph number 3 of the instant writ judgment are set aside and quashed. The state respondents herein are directed to take steps for holding fresh selection of 935 posts of constables by issuance of advertisement in newspapers which are well circulated in the state of Nagaland. The said selection be held in accordance with law. The process of selection be completed at the earliest and preferably within 6 months from the date of the instant judgment. The private respondents herein whose appointments have been set aside by this judgment would be eligible to participate in the fresh selection process. The upper age limit of both the private respondents as well as the petitioners herein shall be given relaxation. However, there shall be no relaxation in the matter of basic qualifications as well as the departmental physical criteria mentioned in Annexure A to the affidavit dated 28/2024. This court has rejected the concessions, relaxations as sought for in terms with Annexure A of the affidavit dated so and so. The private respondents may be allowed by the state respondents to continue in service for a period of 6 months from the date of the instant judgment or till such time fresh appointments are made pursuant to the selection directed herein above, whichever is earlier.
Obliged, my lord.
Obliged, my lord.
I have not given those relaxations.
Obliged, yes.
Obliged, lordship. Obliged lordship.
Yes, Mr.
That order, my lord, at page 62 of the writ petition.
And you have not passed that order also. There was a direction to pass within 3 months.
Perhaps, my lord, the representations, my lord, that has been referred to at page 62, an order passed by this honorable court. It says, my lord, that the petitioners had made representations on 27/3/2001 and 7/8/2002, the annexer 8 and 9. Perhaps those representations are not a part of this.
55 and 56.
It is there.
Page 55 and 56.
These are to the honorable minister revenue.
And received by DC, left hand side.
I do not know, my lord, how come this representations? It is not to the authority.
No, this can't be done.
This is not to the authority. As envisages under the law. This is to the legislator.
What are you asking for?
First of all, if you can provide me patta and khas allotment over the land.
Allotment can it be done? Rule 5 was there at that point of time also.
Only thing is that, my lord, here from since prior to period of 2001 also, we are over their land. When it was
All thing understood. But isn't it required for filing an application for settlement in the form?
my lord, I filed an application for settlement.
Where?
But the order itself says, my lord.
No. Order does not say. If these are annexure A and B, then the order
My
cannot
lord,
say.
your lordship may look into page.
On the
50.
Mr. Roy Chaudhary, on the basis of representation, there cannot be a settlement.
My lord, your lordship may look into page 52 and 53.
These are nothing to do. Where are your applications?
This were by the circle officer, chief revenue assistant to the settlement officer. My application 51, my lord, this is what- Very quickly.
These are only a report. We do not know whether what application is referred to here.
Earlier, there was another round of litigation, no?
My lord.
Some eviction case.
When it was in, my lord, they have converted
by the Board of Revenue, there was a setting aside of that notice saying that the annual patta was converted without giving notice to the original patta holders.
Then
Then, my lord, that order is at page 47. 11 portion, page 48. Thereafter, my lord,
the issuance of notice on the Iman to the annual patta land to the pattada or the transferee is not legally sustainable. Now, what happened to this order? How can you issue after this?
page 48, 47. Page 48, Nana's senior government advocate for the government has adopted the points raised by the appellant in this case.
Before that, the second paragraph, from the annual
From the
pattada.
annual patta holder, the appellant possesses the right of transfer and the government has also not cancelled the annual lease of the appellant. Therefore, the possession of the appellant cannot be termed as transferring. Secondly, even if the annual patta has been cancelled, such cancellation is not legal and binding the annual pattada from whom the appellant possesses the possessory right. An annual patta holder has existing right over the land until and unless his lease is cancelled to issue non-renewal notice. In view of the matter, issuance of notice under section 18(3) of the settlement rules to annual patta land pattada transfer is not legally sustainable. Now, this was the judgment. It was pronounced in the year 1985. And when one read petition 95. 95, I'm sorry. Then
The hook, issue notice making it returnable on 6/11/2024. Mr. R. Bapuzari appears on behalf of the respondent numbers 1. Mr. N. Gusami appears on behalf of respondent number 2, 3, 4. Mr. P. Naik appears for respondent number 5 and 6. As all the respondents are duly represented, extra copies of the petition be served upon them during the course of the day. The petitioners herein have assailed the respective notices issued dated 11/9/2024, collectively enclosed as Annexure 14 to the petition issued by the Circle Officer, Guwahati Revenue Circle, whereby the petitioners were asked to vacate within 27/9/2024. First, from the perusal of the materials on record, it appears that the land in question originally belonged to one Tonuram Koch, isn't it? Belong to whom?
Annexure 1, my lord, your lordship will look at the annexure 1. Originally, it belonged to my lord one great Prafulla Mohan Biswas.
Prafulla Mohan Biswas,
Yes,
and originally belonged to one Prafulla Mohan Biswas and others who were issued an annual patta. In the case of the petitioner that they have purchased the possessory right. Who purchased?
page 32.
Has all the petitioners purchased?
My lord, virtually all.
Not virtually.
But I have not given
Where?
all the annexures, my lord.
Huh?
I have not given all the annexures.
No, we will also consider Mumtaz ma'am, because why haven't you enclosed the others? First of all, why is it not filing separate cases? We'll only consider these. Mumtaz ma'am, he or she will be only protected, others no.
Yeah, if lordship permits.
Because how will they reply, tell me? Tell me, how will they reply?
My lord, your lordship.
Because your order, you see, this order which has been passed, kindly see, this is not the manner. Everywhere, all documents are of Mumtaz Ali.
My lord, but in the writ petition, my lord,
The order passed in the Board of Revenue is also of Mumtaz Ali.
but in the writ petition, all the petitioner's name was there. In the writ petition, that is page 62, petitioner's names were there.
That order I am not considering.
My lord, there is one another aspect of the matter. They have earlier withdrawn their writ petition.
That was on apprehension. This is on notice. There are two separate conservations. That was on apprehension and this is separate conservation. It's a long time back.
If lordship may please to peruse, my lord, paragraph 7 of the writ petition and the order they have also annexed, my lord.
No, this is not done, Mr. Roy Chaudhary. What is this? First of all, why you are not filing a separate petitions?
I think, my lord, they are financial.
Financial? You want money out here for these and you are saying about financial.
Your lordship permits me, my lord, in the other way around, my lord, to file a fresh applications, my lord. They will allow that applications, my lord, till then they will not dispose of me, my lord. That much we will file all our separate applications before the authority. Let them consider.
Mr. Roy Chaudhary, why you are spoiling your case? You have a good case. Either it may be a case that only in the Board of Revenue, there is only one order, one person has won.
My lord,
Others did not go.
my lord,
Others did not go.
my lord. Because their order itself, because the order itself says Mumtaz Ali. Order itself says Mumtaz Ali and no others are names are there.
So others, what right do they have?
Because we are in the same situation as.
Now, have they filed their petitions earlier? The petitions earlier was all along being filed by Mumtaz Jai.
No, my lord.
2297 of
Others name are there.
2023.
My lordship may be.
The others file in page 72.
Page 57.
No,
Page 72, these people have filed it. Where you have withdrawn. But
And
how
my
are
lord,
these people connected out here? Why
Page-
you are filing this type of
Page
petitions?
57 also, my lord, the names are there. Page 57.
There are so many, they don't have money, you don't say that.
Page 57, my lord.
They can approach the legal service authority.
Page
We
57.
give the stay only in regard Mumtaz. Ali.
Others, if others.
Others no, as you have not filed the documents. Others you evict him on the 27th.
My lord, because if they.
Absolutely your fault. And then they may catch hold of Mr. P.K. Roy Chaudhary whenever he is around.
My lord, your lordship will protect us in that.
No,
Or give us.
absolutely
But,
no.
my lord, we will file a separate applications as regards the others. If the lordship will give me a liberty, I will file others.
So why haven't you not filed others? They have a good case or maybe they don't have a case.
I don't know,
Because there is no sale deed.
no sale.
Then what right do you have?
Then, my lord, your lordship may confine this to Mumtaz Ali and others will file a separate writ petitions with the liberty of yours. Others will file a separate writ petition. Or your lordship may allow us to file additional affidavit to that. With those documents.
Today is 20. You have time till 27.
Seven.
You bring it on 23rd or 25th.
24. 24th month. 24th.
24, no, 25. 24 is Tuesday. 25.
We'll bring in affidavit all the documents of others, all the 17 petitions.
Bring it. Otherwise, no.
Not on that, only now your lordship may pass an order.
Absolutely no. You are already protected till 27.
So,
The order is of the, you are to vacate only on 27.
that is. So, my lord, let it come on 25th, we will file additional.
This is the matter again on 25, 7 to 25, 9, 2020. This is not done.
And
I think it's separate.
My lord, your lordship
All,
may,
everybody should file it separately.
my lord, your lordship may please that way that we will file an additional affidavit.
This is the matter on 25, 9, 2024, puts up. In view of the fact that Mr. P.K. Roy Chaudhary, the learned counsel for the petitioner, seeks some time to file an additional application.
Supplementary item 59, fixed at 2 p.m.
What has happened to those settlements? Whether anything is live or something.
No, we have received an affidavit from the principal secretary, which also annexes one document, my lord, dated 17/8/2024.
Item number?
59, my lord,
Some of the motion. Oh, 2 p.m. Yes, yes, tell me.
fixed at 2 p.m.
Submitted
My lord,
their
that
affidavit
shows
as
that
on
the
2 p.m.
Panchayat and Rural Development, that department, my lord, has been
That
withdrawn from,
affidavit is not here.
my lord, withdrawn from the petitioner and given to the CEM himself has taken. So I may not have any case of
Panchayat and Rural Development has withdrawn.
that department has withdrawn from me, from the writ petitioner, my lord. And is given to the CEM himself. The affidavit by the principal secretary.
Yes.
Unnecessarily, you have earned the wrath from your CEO, CM.
Right to CEM, my lord. There was commitment, my lord. The affidavit is here.
Additional affidavit filed by whom?
By principal
this-
secretary, my lord. 4, response number 4.
That affidavit is not here, but anyways. You have a copy of it? It has been brought to the attention of this court on the basis of an affidavit filed by the respondent number 4. That is who is the principal secretary to the North Kachar Hills Autonomous Council. That due to absence of the Panchayati Raj system in the district of Dima Hasao, which is administered under the 6th schedule to the constitution, the North Kachar Hills Autonomous Council Authority had constituted the MAC Constituency Development Committee and had decided that the fund under the 15th Finance Commission grant of RLBs from the year 2023-24 should be implemented by the CDC. It has also been stated that as the CDC does not have proper manpower or expertise of its own, as of now, the committee shall evolve the other line departments like the agricultural, public health, engineering, fisheries, etc., depending on the nature of the schemes. It has also been mentioned that the authority had decided to utilize the fund for development of rural areas through CDC by involving other departments, since the CDC does not have a proper manpower and expertise on its own. Further to that, it has also been mentioned that by the notification dated 17/8/2024, the North Kachar Hills Autonomous Council was pleased to allocate the Department of Panchayat and Rural Development to the Chief Executive Member CM of North Kachar Hills Autonomous Council, Haflong, Houston. Taking into account the said stand as well as the notification dated 17/8/2024, in the opinion of this court, the petitioners does not have any locus standi in the instant writ petition. Accordingly, the instant writ petition stands dismissed on the ground is not entertained on the ground of lack of locus standi.
Item 54.
You had that because of the impleading, you lost it. Yes, Mr. H. Das. What has
I
you
am sorry,
done?
my lord, in this case, my lord, Lanet, my advocate clerk, my lord, has failed to serve copy to him, my lord. I will serve him, copy, my lord. Yes, sub copy to the BPCL and government. Right? Earlier occasion, it was listed, my lord.
No, earlier Lordship, remember, if Lordship recalls, the leaseholder was before this court. And he had filed an additional affidavit that on receipt of the, for the petition for motion, madam, we had instructed the authorities to demolish his property.
No, 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 not.
When he was
that.
confronted with that, Lordship also put a question that why the landowner is not before, now leaseholder is not, he is withdrawn, now this landowner is.
Eviction and seizure.
But here, my lord, in this case, my lord, NOC, my lord, already given, my lord. One joint report submitted and.
Has it been seized?
Lordship?
Done everything?
No, my lord. Eviction operation, my lord, done started here, my lord. They have, my lord, already damaged some of the, my lord, portion of the, my lord, retailer outlet of the petrol pump, my lord, but not completely, my lord. One kindly peruse your lordship, the report what has been submitted by the ADC, my lord, page 53, my lord. Only the legal portion.
Again on 23/9/2024, taking into account that no service of notice has been effected upon the forest department. The registry shall list the incident matter by showing the name of Mr. D. Gugoi in the cause list. Mr. H. Nuts undertakes, the learned counsel for a petitioner undertakes to serve a copy of the petition to Mr. D. Gugoi during the course. Yes, what is this?
Please, your lordship. Lordship, this is petition has been filed against the process initiated by the respondent number 5. An online application has been filed respondent number 6 by reference number NOC 08/26868/2024 to issue a sale permission to respondent number 6 with regard to a plot of land measuring 18 lesa covered by DAG number 6 to 8 patta numbers 376, which is in page number 36. With regard to the same plot of land, a proceeding being MC number 91/2023.
What is this MC number 91?
MC number, already the plot has been sold out to me. I purchased the land. 18 lesa land I purchased.
Then
Then the seller again tried to sell the land to another person, Bilal Hussain.
what is your name?
Amrita
Babulal Haq. So a notice was issued to you by the circle officer.
No.
Then deed of security. What is MC? Mati bikri kora baina potro. Then first check, composite sale deed. So it has been granted. Objection you have filed. Then report regarding EA. Then the land has been sold to you. Then why you are not filing a suit?
No,
Get an injunction there.
the respondent number 5 already permit to respondent number 6 to sell the land, which is included my land.
Go and file a suit immediately. This is not the court out here. This
Kindly-
court is not going to take up all these type of matters of regarding permission being granted or not. No, go file a suit. If you have, get an injunction not to sell.
Pray for before you that please kindly a notice issue to the respondent number 5 to
Notice?
stay the permission.
Absolutely no. I am dismissing it right away. Go file a suit immediately before the registration is done. Challenge the sale deed. But you cannot get an injunction for against this person. This court is not going to do all these things. Permission given and this way. That dispute is between, this is a purely civil dispute. Whether you are owner of the 18 lessons of land, how do I know?
Because we make a sell deed. Make a sell deed.
Tell me I'll get it proved here. How? No. How do I prove it here? Dismiss or withdraw? Which one? Dismiss.
Withdraw.
Ms. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the petitioner would be well advised to file a suit challenging the alleged, the proposed transfer from by whom to whom? The proposed transfer and challenging and to be well advised to approach the competent civil court seeking declaration and injunction against in respect to the proposed transfer of the land by the respondent number 6 to some other person. Accordingly, she submits that she may be permitted to withdraw the instant with petition. Bilal Hussain, nah, we have not made them a party also. By the respondent number 621 Bilal Hussain. Accordingly, she submits that she would not like to press the instant with petition. The learned counsellor for the petitioner further submits that the withdrawal of the instant with petition should not prejudice the petitioner if the petitioner wishes to file a suit challenging the suit seeking declaration and permanent injunction along with temporary injunction. Taking into account the above, this court permits the withdrawal of the instant with petition. It is further observed that closes the instant with petition on withdrawal. It is further observed that the withdrawal of the instant with petition would not prejudice the petitioner if any suit is filed seeking in the before the competent court of jurisdiction. Signature.
Production list item 1.
Yes.
To commission.
Oh, this one.
Can you take my first sometime? I have just telephone.
You see, you ask your sub-register to get it done. Nothing doing. Why this is not given after the person dies? He's got medical ailments, everything is there. Get your instruction by 3:30.
Direct to the council.
3:30, get your instructions. Else we will see the face of the sub-register or the district commissioner. Whom do you want? Today at 4 o'clock. Either. Get the instruction that you are going to get it done. Or 4 o'clock, let us see their face. Yes, Mr. Bijugon.
May it please your lordship. My lord, the petitioner before your lordship is a person who deals in used car sales and purchase. I have that my license at Annexure 1 at page 21. Now, my misfortune is that, my lord, I purchased a vehicle, checking all the documents. It is a Jeep Wrangler Rubicon. And I paid around 52 lakhs and 50,000 on odd to the by bank transfer. Your lordship will find that transaction at page 31, Annexure 4.
Okay.
That's serial number 5, 52 lakhs 500. And the registration of the vehicle is at page 32. Then in regard to it, since I'm a used car seller, I executed a sale deed. Your lordship will find that sale deed at page 26 it starts and 27 is the sale deed. Because normally in our business, what we do, we pay the money through bank. We gather all our resources and then we execute a sale deed. And as soon as we find a purchaser, then we do the necessary formalities and transferred the registration in the name of the purchaser. Now what has happened, my lord? The Nunmati police, they don't serve me any order, they don't tell me any case number. They ask me to now say that you deposit this vehicle in the police station because the person from whom I have purchased is wanted in a criminal case, my lord. And they are putting pressure on me. We have. And the person, they said that they could not trace out this person. So they are saying that you deposit this vehicle in the police station. That's my predicament. No case number, no case, no
And who is
order.
number 5?
Huh?
Who is number 5?
The registered owner, my lord, page 32.
From whom you have purchased?
Yes.
Has the registration been transferred?
No, my lord, we don't do it because unless we find a purchaser, we execute the sale deed. This registered owner will transfer the name in the name of the purchaser. We don't get the vehicle registered in our name.
But is that permissible as per the motor vehicle?
No, that's why we have executed as.
Indeed, is it conceivable?
No, my lord, what is in our line of business, what we do?
No. Line of business is fantastic. You can do many things. I'm not on that. As per the Motor Vehicles Act, is it permissible to have a vehicle of somebody else? You are still not the owner of the vehicle as per the Motor Vehicles.
Well, the owner has no grievance because he has executed the and he
No.
has paid,
If
received the
there
payment.
is- Just for example, it is a case of money laundering. Let us say.
No, they have not said it is a case of money laundering.
They
No
have
case,
not
nothing, madam.
said, as of now, we don't know anything. But the question is, you are not the owner of the vehicle.
That's true, but I'm a
Owner of the vehicle, you have paid. You
Yes.
may very well recover for him.
So my case is that if you think that this vehicle has been purchased, say for what your lordships has said that it is a case of money laundering, then the account where this money has been deposited, that required to be seized first. Then you can come after me because I am a bona fide purchaser of the vehicle. The ownership has not been transferred. It's not that.
There is no bona fide purchase.
No, man, I have
There is
executed.
no bona fide purchase that the money laundering keeps on happening. If you see
No,
what
it's
is
in
the
there, but
definition of,
it's only on the realm of suspicion. Your lordship is saying it's money laundering.
I am not saying suspicion.
Malad.
I am only asking.
No, Malad, your lordship.
No, Mr. No, kindly appreciate. You are not the owner of the vehicle.
No, I don't need to be the owner of the vehicle.
You have no right to maintain the vehicle or keep it with you, the vehicle.
No, he has given me it voluntarily because I have paid the
He
money
may do
and he will
whatever
do
may
the
be,
fun-
but as of do you have the right over the vehicle?
I'm not that whether I have the right, that is a dispute between me and the registered owner.
No.
But Nunmati,
As of now, the owner is him.
my lord, for the moment, my lord, your lordship will appreciate one thing. Can the Nunmati police of Nunmati police station, without any order, without furnishing me or notice, just verbally ask me to deposit the vehicle?
Verbally, no.
That's, so your lordship will ask them to have the instruction by Monday. Till then, my lord, they should not take any course of action against me, my lord.
They're verbally only doing it.
But that's, I have made an, on affidavit, I have shown an oath to say that they can't do it verbally. Let them give a case number, case, notice as per law, then I will take the legal recourse against that, my lord. But verbally, you asked me to deposit the vehicle for which I have paid 55 lakhs. And
You have paid 55 lakhs is a different thing. You may never know why you have paid, whatever it may be. But the question is, as of now, you are not the owner of the vehicle.
like here, ownership is not in dispute. Like here, the Nunmati police
Ownership is
actions
not
I am
the issue,
assailing.
but if there is a criminal case against that owner,
Well, let them furnish me the particulars so that I can take recourse in accordance with law against that case. I'll come with an appropriate application against that case, but they would not harass a petitioner by verbally that you come and deposit. I ask the particulars, they don't give it. Means what is this, Malu?
and why you are making the officer inside Karimganj?
Well, they say that it is on the basis of some information from Karimganj police station.
Where is the PP? Get it from the PP or you can get it.
Yes, my lord.
Issue notice making it returnable on 23/9/2024. Mr. And what is this Ministry of Home Affairs is there? Government of Assam?
Assam doesn't have a ministry.
I'm sorry.
Huh?
So by,
It
I
has
think
to
it's
be Home
caste
Department.
based. It should be Commissioner and Secretary Department of Home.
So how do I issue notice?
Let him correct it.
With
He has to correct it by an eye.
No, we are not issuing notice on one,
Yes, ma'am.
issue notice upon respond number 2, 3, and 4. To stop. For the time being, taking into account that there is no Ministry of Home Affairs in of the state of Assam, this court is not issuing notice upon the respondent number 1. As regards the respondent number 5, this court would consider issuing the notice at a later stage if deemed fit. Mr. Esburua accepts notice on behalf of the respondent number 2, 3, and 4. Full stop. The case of the petitioner's hearing is that the petitioner had entered into some form of transaction with the respondent number 5 for purchase of a vehicle bearing registration number
Last page.
AS10/H/0001. And in that regard, it is the case of the petitioner that an amount of rupees 52,50,000 have been paid to the respondent number 5. It is the further case of the petitioner that the petitioner is in the business of buying of vehicles and then reselling it. And as such, although the payment of 52,50,000 have been made to the respondent number 5, but till date, the transfer as per the Motor Vehicles Act 1988 have not taken place. The grievance of the petitioner, however, is that the respondent number 3 and 4, respondent number 3 have been harassing the petitioner to return the vehicle on the basis of some information received from the respondent number 4. The learned senior counsel appearing on behalf of the petitioner submitted that the said actions on the part of the respondent number 3 is not conceived of in law. And as such, the learned counsel, senior counsel submits that the harassment which has been made upon the petitioner should be stopped pending notice. This court has fixed this matter again on 23rd of
Okay, 23rd would be too early.
25th. Take a phone call and do it. On 25th,
in fact,
issue notice
This
25th.
matter, at least the petitioner would have filed an application before the commissioner. That would have been more prompt and effective. Because ultimately this instruction will,
Hey, what is your vehicle number?
Last page is the registration certificate of the
Then
vehicle.
in the repetition, the prayer, you have made a wrong vehicle number.
Bishop, sir. Vehicle number is AS010H0001.
Then what is at page
Triple-
18?
1110.
0001, madam.
Look, so at page 18,
He mentioned that. Because I take the responsibility, but it was very hurriedly draft last night, my lord. That's why. But I have to take the moral responsibility.
okay, we put that cost upon you for making this irresponsible type of thing.
Printers,
50,000 to the legal services authority. Issue 25 huh? Because so, this court directs Mr. Esburua, the learned counsel, appearing on behalf of the respondent number 2, 3, and 4, to obtain instructions and apprise this court as to under what circumstances the petitioner have been asked to return the vehicle by the police authorities, by the respondent number 3. Till the next date, the respondent number 2, 3, and 4 are directed not to take any course of action against the petitions.
We are obliged, my lord. We'll do the necessary correction by the next day.
No, file amendment petition. You can't do a by
Yes,
then.
my lord, yes. So we'll do it now. That's the procedure. We are obliged. my lord.
Item 10 and 11, order no step.
So we dismiss it,
That is lordship.
withdraw.
No lordship, the respondent number 2 is supposed to file counter affidavit lordship, but they have not filed.
No, there is a clue. Why haven't you taken steps or something? Why the matter? As Lozima Court's order, the petitioner was directed to take first steps for service of notice upon respondent number 2, 3, and 5 by registered post. But no steps taken. Then? Have you taken steps?
Lordship, we are newly engaged lordship. I today itself I present.
Are you going to take steps or not?
Uh,
Are you enjoying an interim order? We
No,
vacate
lordship.
it immediately.
we will take steps by Monday lordship.
The learned counsel appearing on behalf of the petitioner, both the matters,
What the matters?
submits that they are newly engaged in the matter without a bele cover. Newly engaged in the matters, and as such submits that by Monday, that is on 23/9/2024, the steps as directed by the Lozima Court would be taken without fail. This court accordingly directs the instant petitions to be listed after completion of service. It is however observed that in the circumstance that within 23/9/2024 steps are not taken, the matter could be again placed before this court after
Ali Abdullah lordship.
last time.
Item 12. Similar problem, lordship. I've taken steps yesterday, lordship. Already steps taken yesterday, lordship. I missed somebody.
Mr.
S. Chakraborty.
As Chakraborty, the learned counsel appearing on behalf of the petitioner submits that steps have been taken yesterday upon respondent number 2, 3, 4, and 5. Accordingly, this matter after completion of steps.
13,
Completion of service.
Lordship, as per order dated 18/9/2024.
Oh.
As per order dated.
No steps have been received for issuance of notice upon respondent number 1 and 2 at the principal seat. Who is 1 and 2?
Also, this is matter relating to the compensation. lordship.
And if
Oh,
you
that
see-
matter.
Lordship,
So if
all
you
the
see
matters.
Same.
Lordship,
Oh, we fixed it on 4/11 or what?
13,
13 November. lordship.
13 November. Service is complete.
No,
1
and 2 is.
1 and 2. 1 and 2, I think Mr. P.K. Tiwari was representing. Huh? Give a copy to him.
Yes,
I think he will be appearing. Okay. It has been submitted by Mr. A. Chandran, the learned government advocate, state of Arunachal Pradesh, that this petition is connected with similar petitions which are fixed on 13/11/2024. To stop. It is also seen that in respect to respondent number 1 and 2, who was assisting Mr. P.K. Tiwari?
A.R. Gogoi. lordship. A.R. Gogoi. lordship.
That on behalf of respondent number 2, in similar matters, accordingly, list this matter again on 13, along with, give the writ petition number, you have it?
Lordship, it's WPC 2348 of 23.
Petitioner is directed to effect service of the copies of the writ petitions, 2 copies of writ petition upon Mr. So and so. Get his name and ask Mr. P.K. Tiwari to give the name. In the June appear policy supposed P.K. Tiwari to order the EIMs, huh? Side to side. Serve 2 copies upon him
Much of them.
within 3 days.
Item 57, stay vacating.
Yeah, what is this?
May I please, your lordship, I have.
Where is the certificate? Huh?
I have filed the stay vacant petition, lordship, because lordship, at the time of filing this writ petition by the
Where is
petition.
the order?
Order, lordship, page number 15 onwards.
What wrong have I done is because if you have asked for certificating
17
the
lordship.
visa upon hearing the learning and like privacy opinion that the meeting order does not mention anything as to which portion of the building was so constructed that it was causing damage. There is no mention also in the same order as to why the question of objection was not resolved. That's it. It's from time to day, Then
Lordship, it was an ex parte order and a stay order, lordship. And at the time of filing this writ petition, some relevant documents were not annexed, lordship. One,
Madam, one thing, why you are filing this petition? I made it returnable on 11/9.
lordship,
Did I
but
explain
lordship,
it?
school is suffering, lordship, because the school, lordship. has-
Madam, this order was only there till 11/9.
Ye-
What happened? Main
No,
petition, sir.
thereafter that was extended, lordship.
Yeah, extend.
Lordship.
Why? Pursuant to the notice there by this court, so and so are duly represented by so and so. By so and so Galan. She submits that some time would be required for filing a reply. Accordingly, list this matter again on so and so
411.
intent till the next day. Then
Lordship, at the time of filing of this writ
why
petition,
on 11/9 you did not apprise this court not to extend?
lordship, I was there on that day, I did not file, lordship. On the 12/9, we have filed the stay vacant petition, annexing some relevant document showing that the school is suffering, lordship, because the road of the school, 12 feet road, that was enforced by the writ petitioner by 9 feet. Now it has become 3 feet only, lordship. So for that reason, the school is suffering. And the lordship, initial complaint was filed by the school authority, lordship, before the district commissioner. That was not in the record, but I have annexed, lordship, where it is specifically stated that he has encroached the road, lordship, by 9 feet. And lordship, may kindly see page number 36, lordship, of my IA, which will clear the.
Will file reply?
Well, I want to file reply because on 19 I received the copy. 16, not 12.
No,
Have it
12,
on, madam, we'll have it on 4/11.
lordship, kindly see page number 36.
We should have on 11/9 when the matter was taken up by this court, should have objected.
No,
You
lordship,
did not. You
I,
did not. You should have said that don't extend the interim order. I would have immediately thought. All my orders why I pass an interim order is only fixed till the next date. I never give it for any long period, like 4 weeks on it. My orders are very specific. It is there till 11/9. On 11/9, you appear and say, and you are saying about ex parte. That full bench judgment is very clear that the ex parte has no meaning once I have extended. So the matter is there. So we'll hear it on 4/11. Let him file his reply.
Lordship,
No heavens, you are having puja holidays. Your
lordship,
schools,
lordship,
no heavens.
kindly see page number 36, lordship. It's my humble submission, lordship. And page number 36, lordship, which will clear the
Which
problem,
road?
lordship, which will clear the problem the school is facing,
Which
lordship.
is the wall?
This is the wall, the front wall. This is the road school have, lordship. Initially, he has encroached the 9 feet of land, lordship. Now the road has become 3 feet only. In case of any emergency, no ambulance, no fire brigade can enter the school, lordship, by 3 feet road, lordship. Lordship, kindly.
Earlier you had this road.
No, my lord, the submission
Yeah,
I got the colored man. This morning I received.
Lordship can, Lordship, the gift deed I have annexed, in that deed also it is mentioned that
They
12
have
feet
wrote
road.
their northern side, not southern, madam. They are making contradiction.
No, no, Lordship.
Lordship, can you
In-
have a look the photo?
In the gift deed, Lordship, it is specifically mentioned that the road of the school is 12 feet, Lordship. This is the entry, Lordship. And there is a report of Assistant Settlement Officer, Lordship.
Yeah, it's the same, chief.
Same,
Please,
same, Lordship.
this is the same thing, this one.
My lord,
Kindly see.
my land is accurate, my lord. This, yesterday, my lord, Kanango has come. And he has, my lord, measured my land. My land is all
And
right.
what is there beyond the boundary pillars? Whose land?
Somebody other persons.
Lordship,
And this is whose land?
My land is within front.
So this is, the road towards the school is only 2 feet.
No, my lord. What land is at this moment, another person land. And they are targeting me.
Lordship,
My land is all right. They have a road in northern side also.
this is regarding eastern side, Lordship, may kindly see.
No,
my
anyway,
notice.
we'll do one thing. Where is the other side? Who is appearing? Who has passed that order?
That is the power, the demolition order which was impugned in the
It's the development authority.
development authority, Lordship. Yeah,
Where is it?
yes.
You get your instructions. We are going to dispose it of on next day, 4/11. We take it up, 4/11. List this matter again on 4/11, on which date an attempt could be made to dispose of the petition.
Interim order to be continued till then.
It is already there.
No, my lord, because they filed 226(3), man. That's why some order needed.
You see, in spite of that, I have passed the order on 11/9. Interim order passed earlier shall continue till the next date. So it is already there till next date. And it would not vacate because of the fact they filed later on. See the judgment of the full bench. Categorically says that once the court extends in the presence of the other side, it is assumed that the court has also applied the three principles of grant of an injunction, and as such, it 226(3) operation would not apply. Then
There is a report of settlement officer also in my favor, Lordship.
everything will be there. Don't worry.
Deeply obliged, Lordship.
এখানে মেইন ফোনে লিখবে না I cannot list this matter again on 4/11/2023 and 24, on which date an attempt shall be made to dispose of the petition. The instant application be listed in the stay vacating column. Mr. J.I. Bordhuyan had submitted that the interim order be directed to be continued. This court, taking into account that the order dated by order dated 11/9/2024, this court have already directed the interim order passed on 7/8/2024 to continue to the next till the next date, that is on 4/11/2024, does not find it to reiterate again. Find it necessary to read.
Deeply obliged.
Photo, madam.
For admission, item 14.
Case where the son of the petitioner has been missing for the last 11 years, Lordship. On the last occasion, the government advocate was asked to obtain instruction and file an affidavit also. So further instruction. The case is already charged sheet and that line, Lordship, may dispose of the.
Huh? Was Harshit given? Mr. N. Goswami, the learned counsel appearing on behalf of the district, on behalf of the respondents pursuant to the order dated 3/5/2024, have produced the instructions dated 27/5/2024. From a perusal of the said instructions, it is seen that the charge sheet have already been filed in respect to Sonapur PS case number 392/2013, registered under 365 of the Indian Penal Code. By charge sheet number offense report number 93/2024 on 22/5/2024 under sections 120B /365/302/201 of the Indian Penal Code. Full stop. The said instructions along with the status report are kept on record and marked with the letter X. Taking into account the above, nothing further survives to be adjudicated in the instant petition. The petitioner herein, who is the complainant, is the complainant. Complainant would be at liberty to take further steps if so necessary before the appropriate court, wherein the charge sheet has been filed.
All right.
Before the appropriate court.
Item 15.
Loneliness Pathak have been conducted through online. My goodness, Obi, what is this matter?
Police investigation. That petitioner filed an FIR for the police station, which full police station. Saying that my son was murdered.
From police station regarding murder of his son has been published concerns. What does he want? What happened to the investigation?
So far, how evident it goes, my lord, that one charge sheet was submitted partly. And then subsequent, my lord, other two persons were absconding. Therefore, the whole charge sheet was entire charge sheet.
Part charge sheet was submitted against 4 and four. Steps have been taken against the two absconding accused. This was done in 2016. We have not done anything thereafter. Get the instructions day after. Only this, what has happened? All of these people, he is here only. What they have done, as you given the final charge sheet, what has happened? Nowadays it is available in CCTN. It takes 2 minutes to find out. Just put it out there. CCTN, this Hathigaon PS case number, you get it. This matter again on 25th, 25/9/2024, on which state Mr. B.J. Talukdar, the learned senior government advocate, shall apprise this court as to whether the final charge sheet have been duly submitted in respect to Hathigaon PS case number 285/2014.
Only thing. Yeah, then they will the extreme.
This is a very simple, only that we close it, because the petitioner must have got it also. I can't today close it on the basis of this.
Time আছে। It's very funny. So,
Episodes in my matter regards to my lord, I may have been accused in a criminal case, my lord, 2012, my lord. Till now, they have not filed a charge sheet, my lord.
In this case, we have, this is the last instruction of 2021 launch, so I need some after that instruction.
Maybe on the my lord next week.
Writ is to be filed for submitting of a charge sheet nowadays. This is, and we are in how many years? 8 years. After filing of the petition.
Last instruction of
PS case is of 2012.
Well,
21 launch, we have instructions according to that lordship. Non-ship the prosecution sanction from the, for against the.
Huh?
Because the Deputy Commissioner of Police has not received the prosecution sanction law.
Against?
The accused person.
my lord, under 120B and 1013, my lord, UPA prosecution sanction is required. My lord. They have not accorded.
If the prosecution sanction is not recorded, when? By whom?
By the, my lord, Home Department. my lord. Even without my lord prosecution sanction, they can file substitute my lord. Before my lord start, they can my lord, with taking permission from the court, they can file my lord.
But the court can't take cognizance.
Cognizance, my lord, even then, my lord, if I file, because my case is that my lord, 4,40,100 rupees have been seized from me, man. That is my anxiety, man.
How much?
4,44,100, my lord. See, my money, my lord, they have seized while carrying my lord to be extorted money, my lord. If my lord, they have filed the prosecution sanction, I'll pay that, otherwise my lord, I'll get back the money, my lord. That's my,
The prosecution sanction against whom you are asking?
that against the case, my lord, against me, my lord. Because this is a case against me, the petitioner. Then you file a final report, my lord, either closing, my lord, or anything whatever is under 173.
And what is your name?
From the
Money was taken from you,
My lord,
and because of that, and you say that there is nothing out there.
nothing, my lord. For business purpose, I credit them money. There is no proof that I have extorted money.
Huh?
They have, my lord, seems to be extorted money, my extortion money, they have my lord ceased from my position, my lord, that money. Done. Okay, done.
The instant petition has been filed by the petitioner. Being aggrieved by the delay in submission of the final report, submission of the aggrieved by the delay in completion of the investigation in Bokisto PS case number 40 of the 2012. It is the case of the petitioner that an amount of rupees 4,46,100 was seized from the petitioner. On the alleged ground that the petitioner was a active member of the Alpha organization. Although it is the case of the petitioner, it is the further case of the petitioner that the petitioner had nothing to do with the Alpha organization. Further to that, the delay in completion of the investigation have deprived the petitioner of the use of the amount of rupees 4,46,100, which as per the petitioner was illegally seized from the petitioner. The report further reveals that the incident with petition was filed in the year 2016. Almost 12 years have passed by till date. There is no completion of the investigation. Accordingly, the delay in completion of the investigation affects the rights of the person accused under Article 21 of the Constitution. Under such circumstances, this court fixes this matter on 2nd of December 2024. If the investigation is not completed by then, by the respondent number 3, or by the investigating officer of Bokisto PS case number 40 of 2020, well, this court would have to pass appropriate orders taking into account the scope and ambit of Article 21 of the Constitution.
High level.
18.
None appears on behalf of the. Here, what is this?
In this case, only I will take some instruction, Your Lordship.
Huh?
This matter, Your Lordship, relates to compensation for against Your Lordship use of the land by the Power Grid Corporation, Your Lordship. This case is of 2017, Your Lordship. Now, whether they have still, we have come, Your Lordship, for Your Lordship will kindly come to pay. There's an order by the Deputy Commissioner, Your Lordship.
If you are aggrieved by the amount of compensation, then you go under
No,
the
Your Lord,
Indian
that is not
Telegraph.
the case. Your Lordship will kindly come to page 47, Your Lordship. It starts from page 40, page 52, Your Lordship.
Yeah.
This is an order passed by the Deputy Commissioner, Your Lordship, now District Commissioner, Your Lordship. We prayed before this honorable court by way of this writ petition that this direction issued by the Deputy Commissioner should be implemented by the Power Grid Corporation. And thereafter notices are issued, Your Lordship. And in the meanwhile, in identical case, Your Lordship, in respect of identical petitioners, Your Lordship, some order is passed by the honorable coordinate bench of this honorable court, Your Lordship. Now, whether anything survives on this, Your Lordship, whether they have any claim or not, Your Lordship, that I need to take this one. Subsequently, your lordship, there is a notification issued by the central government, your lordship, laying down the manner in which payment compensation will be paid, your lordship. But there is a clause therein, your lordship, which says that it will be effective after 2015, your lordship. Land that has been utilized for by the Power Grid Corporation, that is prior to 2015. And in this judgment, your lordship, there are certain directions, your lordship, at page 11. What is that? Page 11, your lordship will get the directions and the last paragraph.
Has the compensation been done?
Your lordship, at the, when we filed this petition, your lordship, that has not been done.
Now,
Now, your lordship, that instruction I would have to take.
Mr. S. Bottakut, the learned counsel appearing on behalf of the petitioner, submits that he would obtain instruction as to whether the compensation have already been determined by the competent authority under the Indian Telegraph Act, 1885. List this matter again on 28th of October 2020.
Your
19.
Wait, please, your lordship. Lordship, on the earlier date, on 19/8/24, my lord, this honorable court directed the Director of School Education, my lord, standing counsel, to appraise the court regard the status of the proposal as regard the pensionary benefit and BCRG of the petitioner.
Oh, this
Ex gratia matter.
Instruction,
education department,
Lordship.
who is paying for the education? Your education council or the district administration? Everywhere. Who appears for a director BTC? See, this is a very, very old matter. You need to do the needful as fast as possible. The woman has not got the ex gratia on the ground that they have already they will get pensionary benefits. Pensionary benefits have not been given. And 19 years down the line, not 19, 23 years. So this is nothing, it means one has to take it very seriously. The petitioner initially asked for that. However, I converted this position. You kindly see this, what I have written last time. At this note, this court finds it very pertinent to take note of. This is the second round of litigation, and the petitioner has been running from pillar to post for getting the due benefits as per the various memorandums as well as the pension rules. It is also to be taken note of that the petitioner is 77 years old. This court finds it pertinent to mention that an instruction has been placed before this court during the course of the hearing today, issued by the Joint Secretary so and so, wherein it is seen that the file has been moved for necessary views approval of the compassionate family pension to the petitioner. The said communication is kept on record. This court, taking into account the above facts and the reasons assigned for denial of the ex gratia payment to the petitioner, is of the opinion that the interest of justice will be met in the present facts to take up the issue of pensionary benefits, as this is a reason for denying the petitioner the ex gratia payment. It is the opinion of this court that relegating the petitioner to file another petition of questioning the delay in settling the pensionary benefits, that too when the petitioner is 77 years old, would not be in the interest of justice. So now the learned standing counsel appearing for the director of school education to apprise this court as regards the status. Now what the director has done, they have given it to the director of BTC to submit the proposal. We fix it immediately after the vacation on 23rd of October. Ask your director to send it, whatever may be.
Lordship, it appears that the director of education is not a party or the.
Not necessary.
May reflected in the order, Lordship, I'll do the.
No. You see, some things are required. We don't go into these technicalities. You see, the
No, but
petitioner
not
here,
the
no, I'm telling you, the petitioner hearing has approached this court for getting the ex gratia. Ex gratia is denied on the ground that she has her father means they are going to get pensionary benefits. If that be so, then why from last 23 years she has not got it? The director of school education is not made a party out here of PTC. And this I made the director of AIA. Last time here these people are there, na? Director of school education, Assam is a party, na? Huh?
My lord, the petitioner's health is deteriorating day by day.
Hmm?
Health is deteriorating day by day now.
I understand.
Process may be expedient by the responding authority.
No. Pursuant to the order passed by this court on 19/8/2024, Ms. So-and-so appearing on behalf of the Director of School Education, Director of School Education, na?
I am for respondent number for Commissioner and Secretary, Government Education Department.
Appearing on behalf of the respondent number 4, have placed before this court an instruction to the effect that that in view of the observations made by the ARTPNPG department, A letter was issued on 10/9/2024 to the Director of Education BTC Kokrajhar to resubmit the pension proposal again to the department as per the government notification number PPG bracket P oblique 75 oblique 91 oblique 242 dated 29/3/2000. Full stop. It has also been mentioned as per the said instruction that after receiving the required information from the Director of BTC Kokrajhar, necessary follow-up action would be taken. The said instruction is kept on record and marked with the letter X. Full stop. Taking into account the above, this court impledes the Director of School Education, BTC Kokrajhar, as the respondent number 7 to the instant repetition. Full stop. The petitioner herein is directed to file a fresh memo of parties before the registry of this court within 3 days. And the registry shall, on the basis of the instant order and the fresh memo of parties, shall make necessary correction in the cause title as well as update the same in the CIS. This court, during the course of the proceedings, this court, taking into account that Mr. B. Chaudhary, taking into account that the standing counsel for the BTC, Mr. B. Chaudhary, was present, had this court, Mr. B. Chaudhary, the learned standing counsel of the BTC, who was present in the court, had accepted notice on behalf of the respondent number, newly implemented respondent number 7. Is directed to the Director BTC is directed here to resubmit the pension proposal as requested by the communication dated 29/2024 by the Undersecretary to the Government of Assam, Department of Education, School Education. The document which is kept on record and marked with the letter X be also provided to Mr. B. Chaudhary, the learned counsel for the BTC, by the counsel for the respondent number 4, so that he can take appropriate steps. List the matter accordingly on 23/10/2020.
Deeply obliged.
You file your memo parties.
Deeply obliged. That's only.
In this case, Lordship, I have talked with the Deputy Commissioner Lordship. Today, he has handed over his file, he has the expert to the Lordship. And I have also talked with the sub-registrar. Informed him, he has placed the matter before Deputy Commissioner, and he was give the file to the ADC for comment also. And the concerned ADC is on leave also, will join by Monday also.
This matter again on Tuesday. On which date Mr. N. Goswami, the learned counsel appearing on behalf of the district administration as well as the sub-registrar, Karimganj, shall apprise this court as to whether the concerned authorities have permitted the commission, permitted the applications so submitted by the petitioner for issuance of permission. To get it done. That's it.
Item 20.
May I please the Lordship? The last occasion, my lord, government took time for filing the affidavit, my lord. My lord, the issue herein is that, my lord, in the year, my lord, 1976, my lord, the government has taken some land for, my lord, for the purpose of, my lord, defense department for, and my lord, in the meanwhile, my lord.
What do you want? Directing the respondents for restoration of the patta of the land of the petitioner by making necessary correction in the relevant Jabavandi. What happened?
Page 24, my lord, kindly peruse, my lord. What happened, my lord, our name, our DAG number has been recorded as a, Sarkari land, government land. But they have never taken the position, my lord. And even, my lord, no compensation has been paid to us, my lord, as a land
Therefore,
acquisition.
restoration of people and humble submission is that as per the order dated so and so passed in land acquisition officer dated so and so was converted into government by way of acquisition in favor of the effect. As per the land records, land measuring 1 bighah of Mara class converted the land mentioned. As per the report furnished by the employee of the land record after carrying out the local investigation, the land sale beyond the boundaries of the land.
Still, we are in position, my lord, in the land, in that land, my lord. Still, we are in position, my lord, in that.
They are in the possession, Lord.
But it is still in government land
Sure.
market. Why?
My lord, the market.
It is a whole method logic, so they could not.
Mr. N. Goswami, the learned counsel appearing on behalf of the district administration seeks some time to obtain instruction taking into account that the instant matter is an old matter, pending matter. Was to list this matter on 4/11/2024, on which date the council, the council for the district administration shall obtain necessary instructions as to what steps have been taken pursuant to the request so made for making necessary correction to the patta of the petitioner.
Page 20 lots, there is a report of the High Court official lots.
What does it say? Page 20.
Lots.
It says, my lord, petitioner are in possession, my lord. And we are filing application for paying the revenue, my lord. Pursuant to that, my
Now,
lord,
what steps have been taken pursuant to the report, pursuant to the request made by the petitioner for making necessary correction of the land records? But it is in acquisition.
yes, my lord. My lord, by mistakenly, my lord, our dog maybe, my lord,
Okay, let him get the instruction.
I'm deeply obliged.
Yes, what is this?
Matter was mentioned by the private respondent, madam.
What is your case?
The matter relates to the petitioner filed an application with the revenue board for impleading the requisitioner in appeal filed by the private respondent 7 and 8, madam. The info noted at page 93, madam.
You filed an application for what? Implement.
Implead,
Then that was rejected.
rejected,
Against that you have come.
yes.
Why?
And because, my lord, the patta has filed an application with the SO for correction of his patta. For correction in the sense, deleting the name of the tenant,
Delete the
name of tenant. The one tenant name was included in the patta, in particular the tenancy was created by an order passed by the assistant settlement officer, creating tenancy in respect of three tenants. Only one tenant's name has been included in the patta. Against that,
Who are you?
I am the tenant manager whose
Your name has been removed.
yes, no,
Who?
not recorded in the patta.
Huh?
Not recorded in the patta. Only one tenant's name has been recorded in the patta.
No. Who has filed the appeal?
Appeal filed by the patta
Against?
against inclusion of only one partner tenant names in the patta.
No. Your name were there. Was there any order passed for removing your names?
No, my name was not there. Only by an order, along with the other two tenants, tenancy was created. in a particular land. But only one tenant names has been included in the patta.
And that was challenged.
That was challenge.
Then what business you have in that matter?
But the order is the same, my lord. That order is, my lord, is, my lord.
But your case is, it is not against you.
No, no, my name has not been, I am, if, my lord, the case is gone against the, my lord, the recorded tenant, my lord, that,
Now, do you derive title from that person against whom the appeal is filed?
I am only want to include my name in the patta as a tenant, because the only one tenant's name has been recorded in the patta. And that, well, if you also kindly see the order, my lord, by which the tenancy was created.
Where?
Well,
No, where's the impugn order?
Impugn order, my lord. Page 93.
Page
93.
Appellant's advocate present in person, heard learned counsel for both of them on the issue of impeachment of Gulapi Das and Amir Ali as responding. Peruse the petition filed by Gulapi along with the non-impeachment made reveals that the appellant filed by the instance. Who is they paying for the state, the other respondents?
They have mentioned this matter for, by order, this matter has come. In earlier occasion, in two
Who
occasions,
is they paying for them?
actually, the Mineral Jivan Guru is a practicing advocate of this. Honorable Court. The respondent number, he himself an advocate.
Who?
Mineral Jivan Guru. Respondent number 7.
Is this matter come up on mention?
Yes, by order.
Who
They-
mentioned it where?
They have mentioned.
This court? I've never permitted such mentioning. How did this matter to me? কোন কোর্টে দিতে দাও 17 মেনশন করেছে ট্রিবিউনাল পিটিয়ে দিয়া আরেকটু এই ধারণা The instant matter was listed at the behest of the learned counsel appearing on behalf of the respondent as he had mentioned the matter. However, when the matter is called, the learned counsel for the respondent is not present. Accordingly, list this matter after vacations. Interim order is there.
I know this matter relates to the refund of the previous.
The statutory appeal before the Assam Board of Revenue, since the matter has not been taken up due to lack of forum. Lordship, we preferred the repetition before this court, and this court directed for listing, issued notice and fix the matter on 4th of November. Lordship, this matter may also come up along with this repetition.
4th of November.
November,
There is no stay.
yes. Yes.
Eh?
Even then,
The principal amount where my client is facing real financial hardship, my lord, the principal amount may be released with some interest, because he is ready to execute a bond, my lord. If in case the appeals are allowed, he will execute a bond to that effect.
No, if you get that requisition allowed, you get the money back. Doesn't they have properties? What business are you carrying on? Or you have stopped?
Business, it is a bonded warehouse, my lord. So,
There is no bonded warehouse.
my lord, the,
As of now, there is no bonded warehouse. Yes, are there where there is a manufacturing. You have a manufacturing.
Manufacturing is there. Not under the name of the petitioner, my lord, but
No. It has to be one. You are a warehouse now. Wholesale warehouse.
Also, with regard to the, what my friend is saying about giving a bond.
Huh?
Lordship, that if Lordship, as my friend has submitted that they are ready to execute their bond. Lordship, with that regard, Lordship, I have to take instruction on that basis whether,
Why I'm saying is,
yes, Lordship.
see, the only question I'm not on that. You return whenever, but who is going to pay the interest?
Last occasion also, Lordship,
The interest aspect, I'm worried. You see, it is after all the state's money. State money is your money, my money, everybody's money. It's a public exchequer. So, wouldn't it be proper to pay that principal, whatever it is, and keep it in the interest then won't accrue. Right? We'll consider as regards the whether he is entitled to the interest or not, that is a different thing. But what about the principal? They don't pay it. You can very well, they will give a bond or undertaking or whatever may be taken.
that situation, Lordship may fix up any day, giving me a short time, Lordship. I will try to get the instruction.
Other matters are fixed on 4.
Yes.
Sir, how do you have waited for such long? Why not till 4?
4th of November, man. Serious financial hardship is faced by my client. He is also pressing very hard.
Pressing you hard, not the young. But the thing is, you have waited from 2022.
We have waited, but we filed a repetition.
22. No? And therefore, I'm saying, no, let us, we can wait till 4:11. If I dismiss you, his petition, provided I'm sitting in the bench.
Again, that question will come along 4th again if both some finality is given to this application, at least this petition before your lordship, then I can explain.
Okay, this matter again on Mr. G. Rahul, the learned counsel appearing on behalf of the petition, expresses that the petitioners are facing great financial difficulties and the petitioners are willing to submit a bond if necessary for the release of the principal amount to which the petitioners are otherwise also entitled as per law. Mr. B. Chaudhary, the learned counsel appearing on behalf of the Finance and Taxation Department, submits that he will take instructions in that regard. This matter again on 30/9/2024 at 2 p.m.
2030, I'm some higher job.
Huh?
27.
What 20?
27 or 9.
Why?
But 13, I'll be out.
Okay, we'll have it on then 4.
Lordship, let it come on, then let it come on 4th of October.
4th of October, then,
4th of October, the last date.
and then can I pay for 27th of September? My lord?
When is
I
it?
apologize, my lord, but already a matter is fixed on 13/9. I'll be out of this.
First.
23.
Lordship, my lord, I pray for compensation. My lord, this lofting house was situated in my Patna land. And my lord, as per earlier order, 27/8/2024.
Oh, Rajpur, Lucky Rajpur.
My lord, yesterday filed this affidavit, my lord. In this affidavit is mentioned, my lord, this Patna land in my lord. And the additional evidence.
Your affidavit, when did you file? Not here. What is your stand?
As far as my lord, my learned friend affidavit say that, my lord, this, my patta land is situated, my lord, this, watch post police station, my lord.
Huh?
My land, my lord,
In Dag number.
my dog number and patta number, my lord. My lord, the watch post is situated, my lord,
One pole, what sports is situated?
situated.
Then,
Yesterday, find this, my lord, affidavit in. public.
as to whether he has received any instructions in which dark number the land, in which dark number the land is situated, wherein the lockers has been situated. The learned counsel for the, however, submitted has no instruction. So as per you, the land, the lockers, police outpost, watch post is situated in his land.
Lordship.
Then what was the basis?
Because that
on
was
which-
recorded as government has land till 2010.
How?
No, my lord.
How? Earlier to that,
Because it is from 1961 to 2010.
okay, it has been submitted by Mr. N. Goswami that an affidavit has been filed by the respondent number 4. You want to file a reply?
Yes, my lord, already I filed the additional affidavit already.
Do you want to file a
Yes,
reply?
yes, my lord, my lord.
So Mr. Zaid Hussain, the learned counsel appearing on behalf of the petitioner, submits that he would like to file a reply. List this matter again on 6th of November 2024. The registry shall bring on record the affidavits which have been filed by the respondent number 4. So the petitioner shall file the affidavit in reply by 4th of November 2000. Earlier, Stan, what you want to clarify?
Lordship, I can say first, Lordship, I can say first order dated 22/5/2024.
22/5. In response to the query made by the council, as to why the petitioner's claim being granted under PM and current council has No, there is some conflicting. I asked them to file an
Yes, yes,
additional
yes.
affidavit.
And again, another order passed Lordship by on 15/7/2024.
15/7.
Yes,
Leave that.
both the orders are not complied with.
Yes, why you have not filed an additional affidavit? So many times it has been granted.
That's it, in this matter, some developments are there, therefore we want time to place the development.
Who
along
is
with
to
the-
file the additional affidavit?
That's it, we have some
Who is to file the additional affidavit?
video. But let's say that after the data.
Disposed by the order dated 15/7/2024 had directed the video, the PNRD department to file the additional affidavit in response to the specific involvements made in paragraph number 10 of the petition. Such affidavit was not also when the matter was listed on 12/8/2024. The council appearing on behalf of the PNRD department again sought for an accommodation. And this court thereupon directed the affidavit be filed on 13/9/2024. And the instant with petition to be listed on 29/2024. However, there is no affidavit filed, additional affidavit filed. Taking into account the above, lists this matter on 4/7/8/11/2024 at 10:30 AM, on which day the Block Development Officer Moriabari Development Block shall be present to the video conferencing link and further file an affidavit as to why, in spite of specific directions passed by this court, there is no additional affidavit filed. In addition to that, the said official, that is the respondent number 6, shall bring on record the clarification as sought for in the order dated 15/7/2024 in respect to paragraph number 10 of the affidavit.
The amount has been sanctioned by the finance department on 18/9. Now, my lord, by Tuesday, my lord, by Tuesday, the GAD department will submit the proposal for FOC. So, well, it's under my lord consideration. In a short time, it will be paid. Sanction has been given by the government. The moment the FOC is given, my lord, the amount will be in the exchequer of the GAD department. Then after the formality, it can be.
The
So,
CAT has to
short
give
time, my
it.
lord.
CAT has to give it to the deputy commissioner who then will release it on the signature. Or
Some
whatever.
Further, my lord, short time.
7 days before vacation.
Lord Civil posted, my lord, on 3rd or 4th, my lord.
Pay the money.
Yes,
I
Lord-
passed a very long order.
Yes, sir. Lord Civil indicate some more, time. No, some indication in.
Where is the
so that
financial
I can
sanction?
communicate, my lord.
Where is the finance sanction?
On 18/9.
Show me.
Ma'am.
Then only, otherwise I was directing here na, to
Yes,
for
ma'am.
nullifying the entire proceedings for acquisition. 7 days you paid. Given by the finance department?
Yes. My lord, the GAD department will now have to again move the finance for FOC approval.
Nothing.
Lord Civil give us some-
Otherwise, return the
Yes,
land.
they will pay.
Return the land.
No, they will pay.
There's other
Yes.
lands.
But I hope, my lord, the petitioner.
You have good land out there near Zagi Road. Go there.
Petitioner can wait for.
No, ask the DC office to go to Zagi Road. Nothing.
We are more happy with the land rather than the complex.
Yeah, they are
It's a
happy.
very prime land, my lord.
So have them, give them the land. You have no money. Let the land be there. No money.
After 10 days, on 3rd.
But clear it. Otherwise, go to Zagi Road.
Yes.
There are a lot of very big plot of land. Khetri comes under the district administration of here, na, Kamrup. Khetri? Yes. Go there. There are a lot of fields out there. Anyways, you are taking, and the district administration would have no problem with chapter 10. Government office can already
It can
have
happen
it.
in the
There are a lot
belt
of
area.
lands you are going to evict. So now get it out there. Have your district administration there. This is under the district here, Kamrup. Why you are troubling the petitioner with his land? 10 days.
On 5th.
Not fifth. Fifth, I am not coming to the court.
Court instruction, my lord, she will close the petition on
Court,
5th.
court is the last date. Court is closed on 5th. Court is
Sorry, ma'am, on 3rd. day.
Mr. B. Gogoi, the learned counsel appearing on behalf of the GAD department as well as the finance department had submitted that the financial sanction has already been granted by the finance department of the government of Assam in respect to an amount of 214.04 lakhs. In that regard, he has placed an instruction which is kept on record and marked with the letter XYZ anything A, B. These land acquisition matters now. I have now started to mark it somewhere else. X. This is the first document. And apply a X. Full stop. He further submits that after the said amount is sent with the financial sanction being approved by the finance department, certain other formalities are required, which are likely to be completed within 10 days' time. Accordingly, this court fixes this matter on 3rd of October. We apprise this court as to whether the amount has been disbursed to the petitioner. Published accordingly. H.R. Chaudhary, who submitted by the other entry has been filed by the petitioner today to the affidavit filed by number 5.
Submitted my reply. My lord, in this case, my lord.
Oh,
Yeah.
that one.
Yes.
What happened now? You were supposed to shift as per the order. What happened?
Then subsequent, my instruction is that
Because
probably.
your Anganwadi center cannot be at the convenience of the Anganwadi worker. It has to be to the convenience of the people. Because
This is the latest. My lord, my submission, kindly see page 35 of their affidavit.
I don't understand why. What is wrong?
My lord,
I don't understand this.
This is in response to your lordship's order dated.
Yeah, no, you see, kindly see. You said that you are going to construct a new one. You see, the committee of so-and-so, the man notified that so-and-so, the committee found that the present site of the AWC is not suitable to the model AWC and does not possess the required amount of land.
Right.
The committee took resolution for construction of the model AWC at a new place which is within the jurisdiction of Iman. The deponent further states that the director so-and-so issued a letter for construction of the Iman wherein it clearly mentioned that as per plan estimate the size of the new so-and-so. Then,
It has to be my lord, 2000 square.
then what happened?
Therefore, my lord, the earlier site was land, did not have that much of land, so we have to shift it. By decision of the board, committee. Then, lordship, that land, the present land was donated by someone, lordship, we have stated it.
Then-
Started.
No, you now wanted to shift to a new place, which will be around 1800 square feet. In there, I understand, but what is this letter?
This letter, lordship possibly by last order dated 2/8/2024. Directed to
What steps have been taken for construction of here pursuant to the decision to construct an Iman at a new place which is within the jurisdiction of Arigul Tea State? Then you say that there is a stay, construction stay. Issued a letter to the so-and-so to stop the ongoing construction of the Iman with an intimation to the director of so-and-so. Bidder is here mentioned that being a CDPO, I have no authority to take any steps in this regard as the matter is dealt by the district administrator as well as the Department of Women and Child Development.
Child Development Authority also, I have written, but there is no response.
Huh?
This Women and Child Development Assam.
Ah.
I had also informed them, but there is no response.
Money has also been released for construction.
Part of them.
But why did he stop it? Who appears for the Director Women and Child Development here? And the DC Karimganj, you appear.
Yes. It's a very good one.
It's a black box. Yes, what did you want to show?
My lord,
Page?
in their affidavit, on page 35, there is a, my lord, order Women and Child Development Assam, 7 February 2023, for construction of new model Anganwadi center. In this respect, my lord, they may construct a new Anganwadi center, but they are not constructing new Anganwadi center. Anganwadi center 165 number Anganwadi center is going on. But they are constructing far away from 3 kilometers, far away from the main center. Now constructing are saying that this is a 165 Anganwadi center. This is not a new Anganwadi center, man. Anganwadi center which has been exist 11 surveyed area, man. They may construct, I have no issue, but they are not constructing. They are actually, my lord, releasing fund in the name of my Anganwadi center.
They are releasing funds,
Yes, but they are using this fund, my lord.
but not
They're
constructing.
constructing, but they are trying to construct, my lord. This is, they are not constructing a new Anganwadi center, my lord. This is the issue here. This is the 165 Anganwadi center, and this is going on regularly without any break. Everything is going on. Surveyed area, my lord. All formalities are filled up.
Is this matter even on 28/10/2024, on which date Mr. B.J. Talukdar, the learned additional senior government advocate, shall obtain instructions as to why the construction in respect to the Anganwadi state, ongoing construction of the model AWC Iraligu Estate have been stopped. Mr. Gordon. Yes, Matidio. Yes, what is this?
Which act will be applicable, Lordship, in respect of some compensation in laying gas pipeline? It's the Act of 1962 vis-a-vis the Act of 2013. The issue is that.
This is under what acquisition under?
Mineral Petroleum Pipeline Act 1962,
That is only a right of way,
right of use,
right of,
use,
right of,
right of use.
right of use is different from land acquisition. Some,
In 2015,
Hmm.
there was some modification in the Act of 2013. Lordship.
now the judgments have been passed.
Lordship.
Now, once these judgments have been passed, under what provision? Where are the judgments?
Page 78,
75.
78, Annexure 12.
Yes, again.
Here, issues were framed.
Tell me one thing, how is this repetition maintainable? Huh? How is repetition maintainable? Huh? How is the repetition maintainable? Tell me. This is the proceedings under what? It's a reference proceedings. Against the reference proceedings, a writ is maintainable. It's a judicial order. How do you pass? Huh? Who is your senior?
K.N. Chaudhary will reply.
Huh?
Mr. K.N. Chaudhary, senior consultant.
K.N. Chaudhary. Yeah.
Begum, court number 20.
Let me file an affidavit, Lordship. I'd like to, I'm appearing on behalf of the state respondent as well as Gail. I would like to file a very short affidavit, basically what the maintainability point we're also raising nowadays.
Because this is, I think, repetition can be maintained. 227 maybe. But the question is as to whether there is a right of use. Right of use can be compared with the land of acquiring of the land.
Interesting question of law from that perspective regarding the forum.
Forum is there, but then also forum, first of all, I have serious doubts. 227 may be there, but not 226. Difficult. Because if you see the public premises, they don't allow. The Land Grabbing Act, they don't allow. 226, these are not there. Okay. I'm ready. When?
2 weeks time will be difficult.
This matter on 4th of December 2024. In the meantime, the state would be, and the respondents will be at liberty to file their shall bring on record their stand by filing their affidavits.
Highly open.
Lordship, in this case, your government advocate is referring lordship and according to this.
Just for a moment, kindly see the order 7/8/2024.
Affidavit file.
Instruction received, lordship. Instruction received, lordship.
Huh?
Instruction received, lordship.
You want to file affidavit?
Lordship, we'll file. We'll file, lordship.
Mr. N. Goswami, appearing on behalf of the state respondent, submits that their instructions have been received and the affidavit will be filed without fail on the next day, on or before the next day. This matter again on 13th of November 2024. The affidavit be filed by 4th of November 2024. Petitioner, if so advised, will be at liberty to file the reply. Interim order passed earlier shall continue till then.
Okay.
May I please, your lordship? My lord, on the last, 2/9, lordship was pleased to grant time. And for filing, my lord, interlocutory application. I filed one in IA is there, my lord. IA
You want to
number-
make whom a party?
Lordship.
MLA?
Yes, my lord.
Why?
My lord, because.
Oh, I see.
Yes.
There is an application filed by the petitioner to include the opposite party herein as a response to array the opposite party herein as the respondent number 7 to the accompanying petition. This court have duly taken note of that the relief which have been sought for in the instant petition cannot be passed without including the opposite party. According, the opposite party number 7 being a necessary party, the said he is the opposite number 7 being a necessary party is made he is arrayed as a respondent number 7 to the accompanying petition. Petitioners shall file a fresh memo of party within 3 days before the registry of this court, and on the basis of the said memo of parties, এখানে by কে লিখে দিবেন, হ্যাঁ? আর কিছু লিখে এখানে দেখে main কিছু নেই না। Issue notice upon the respondent number 7 by way of registered as well as usual, returnable on urgency, no urgency.
Urgency, my lord, that my lord, my lordship was also indicated that my lord on 5/8 and 29/6. My lord, to consider the interim 5/8 lordship kindly say. And 29/6, there was an order to consider the interim pair, my lord.
Oh, that matter.
Yes, my lord. that-
Okay.
So my lord,
Issue notice, we make it returnable on a fixed date. Issue notice making it upon the newly included respondent number 7, returnable on 6th of November 2024. Full stop. Steps be taken upon the said respondent number 7 by way of registered as well as usual within 3 days. In addition to that, Badasti, the petitioner is also given the,
registered will do because MLA, my lord, if petition will.
if he is not served, then the problem arises. Otherwise,
Okay, my lordship will serve. Will serve justice service.
is also given the liberty to
Yes.
take steps by way Dasti upon the newly included respondent number 7.
Prayer is, my lord. So far interim prayer is concerned, my lord. If my lord, they modified this scheme, then my lord, everything will infect us. My lord, status quo as on today shall be maintained. With regards to,
Modify what scheme?
my lord, so far my lord, what happened pursuant to a court's order, my lord, this honorable court's order. My lord, some amount was released to one panchayat government GP to another GP, and thereafter, my lord, proposals were made in terms of 126 of the Assam Panchayat Act 1994 for taking up skill. There, 126 provide for taking skill for planning commission by.
Who are you?
I am the ex-president of the GP, my lord. And during my period, my lord, these schemes were, my lord, proposed. And after that, in terms of the provision of 126 of Assam Panchayat Act,
pro Gauss-Sova, my lord, it should. What happened, my lord, pursuant to that, my lord, recently what happened, the Gaon Panchayat is not, no more GP presidents are no more. Then what happened, MLA has given a note to modify all these schemes, my lord. And I have annexed the document.
The interim order would be considered in the next stage. And madam, you get your instructions. What is this? So,
Instruction was sought for
in the
in the past.
meantime, this court further directs the respondents authorities to bring on record their stand by filing the affidavit without fail. Oh, these matters.
Yes, they filed an affidavit in opposition just today, just now itself.
In all the three cases, my lord, 32, 33, 34.
Done.
Affidavit of opposition they filed, they have stated that the cases are closed. Well, that, in my submission, we have to file a rejoinder to that because by closure of these cases, my appeal procedure has completely been nullified. Because there's a time frame for appeal. That time frame became a non-starter because of the non-uploading of the documents till date. So my time frame for appeal never started in the first place. Now, yesterday's order, there's a letter annexed to the affidavit 99, which says that this has been closed.
Let's see what did you challenge. You want to file an appeal against what order?
My lord, the order of provisional demand, my lord, that's
Huh?
of the demand which has been assessed, the penalty and the tax.
Or under 73?
My lord, not under 73, my lord, this 129, the demand which was made, 129.
Of
Of the Assam Goods and Services Tax Act.
Assam Agricultural?
Assam Goods Services Tax Act 2017 and the Central Goods Services. Tax.
What is this 129?
My lord may take it up to, I may read that impugned order of,
Detention, seizure and release of goods and conveyance in transit.
yes, certain goods were caught in, seized in transit and said that there was misdeclaration or concealment of particular products. A demand is raised in respect of the concealed value of the goods or evaded, the tax sought to be evaded as well as penalty. That is paid. Option is given to the SSC, pay and appeal or do not pay and appeal, but 25% minimum has to be paid. We paid entirely in full. Thereafter, we under protest that we would lodge an appeal in the expectation that we'd be lodging an appeal on certain legal grounds. But because of the fact that the payment was never reflected on the website of the authorities and the filing is by way of an e-appeal. So when the relevant field comes up as to what amount has been deposited, that is never reflected on the record.
The so-called notice paper to they paid the amount. How did you pay? Did you,
paid directly.
did you inform it? They concluded when? 1999. And when you are filing this reputation? Then?
Really, my lord.
How is it possible?
How is it possible?
On one hand, he is filing a writ petition challenging that I want to keep on filing an appeal. Matter is pending. And what is this? You have issued this note on to a day before yesterday or today?
Yesterday.
And yesterday, what is this? That you are concluding, accepting that he has no issue. Isn't this? This on the face of it is wrong. You file your appeal. If it is not there, you file your appeal. If you have already paid, they are not showing it, you file it by hand. Manually you file it. If they don't accept, we'll give you the permission. Here is not because of their fault, it cannot happen. File it by hand. And this is an admission that you have paid. And because of that, you have paid and you have not been permitted to file it this way. And we said that this document also. Heard Mr. N. Bulwer, the learned counsel appearing on behalf of the petitioner, and Mr. B. Gugoi, the learned counsel appearing on behalf of the respondent numbers, petitioners appearing on behalf of the respondent numbers 1, 2, and 3. What is the difference in all these three?
One of the cases, my lord, there was no order of demand at all. Despite that, in two of the cases, there is a final order of demand. We have paid. In one of the cases, there is no order of demand at all. Therefore, my lord, my submission in that case may not be disposed of because there's a legal aspect coming. There's a timeline of 7 days within which a notice has to be issued. The demand has to be assessed and submitted for the SC. It has now been almost a year. No demand notice has even been issued till now.
So we dispose it of the, so if there is no demand, did you pay that?
I still pay. Provisionally, I still pay.
Without the demand?
Without the final demand. Provisional demand is there.
Against the provisional payment?
Yes, yes.
So you want to file an appeal against
I
that?
want to file an appeal. I'm been permitted to take that ground in appeal regarding the issue of limitation.
And the other two?
Other two cases, the final demand was there. I paid.
The same 1999 order on the other two. 1999 order has been passed in the other two.
Not in that one.
Not in that.
So that case, let it remain. So which are the two cases where 99?
93 and 3417.
3417.
Huh? 3392?
992 is the other one.
The other one. That was the one where which I was about to discuss with you. Mr. And why there are two demands?
My lord,
Why there are two demands, two petitions?
my lord, because there are two express consignments have been seized
Again,
at
different
times.
consignments.
Different consignments seized at different times by at different places.
So and so, so and so. The petitioners herein have filed both the writ petitions, that is WPC number. Now, filed the instant writ petitions. Being aggrieved by the actions on the part of the respondent authorities in not reflecting the payments to be made, payments so made by the petitioner pursuant to the final demand raised. At this stage, it is relevant to mention that because of non-reflection in the website, the petitioner is also not in a position to file the statutory appeal. And it is under such circumstances, the petitioner therefore has approached this court by initiating both the writ petitions. WPC number 3393/2024 heading date. In the instant case, it will be seen. Now, in the instant case, the facts which can be discerned is that on 10/11/2023, a transport vehicle bearing license number AS01GC6671 transporting SS1 chewing tobacco oblique pan masala products were intercepted by the respondent number 3 and detained due to some discrepancies in documentation involved therein. Accordingly, proceedings under section 129(3) of the Assam GST Act, Goods and Service Tax Act 2017, foresaw the State Act, were initiated, and a show cause notice dated 10/11/2023 under MOV-07, MOV to all caps, informed GST DRC-01 was issued. The petitioner accordingly submitted the reply thereto on 10/11/2023, rebutting the allegations so raised. In addition to that, the petitioner, taking into account that the goods which were detained by the respondent authorities were perishable in nature, decided to pay the demand of tax and penalty, and accordingly, the said amount was paid via net/online banking on 10/11/2023, and the entire demand amount of rupees 6,21,250 was paid in full with acknowledgement receipt delivered by the authorities of the payment made against SCN number dated 10/11/2023. On the basis of the said payment, the detained goods of the petitioner were released. You paid some penalty also.
Entire amount, that is inclusive of tax and.
That is 6,21,000.
That is 6 lakh.
Thereupon, the petitioner was preparing to file an appeal against the demand raised.
One 129.5. 129.5.
I'm coming to that. Let these facts be. I didn't understand that it is stated that when the petitioner was preparing to file an appeal against the demand raised, it was noted that the authorities had not yet to issue even the final demand order of penalty after considering the reply filed by the petitioners. So final order has not been passed.
Yes, my lord. Final order has not been passed.
In this case also, all cases.
No, in the other two cases, final order has been passed. After,
Mister, I am on 3393.
yes, I'm also on 3393,
So that is where final order not passed.
not passed, but still payment has been made against the provisional order for getting the goods released.
So this was the case which should have been kept.
It should be kept because the issue arising here is that within 7 days, they have to pass the final order of assessment, otherwise entire proceeding moves. So my lord may keep this on that point of law. Or my lord may remand it back giving me the liberty to raise this specific point of law before the authorities. That is, in this case, only that question would arise as distinct from the other cases.
Mr. Borua, I said to you, no, I told you, you said 3393. Therefore I kept 3392 aside.
Yes.
But then also why didn't you say after giving half of the dictation, you make this thing like this?
No, my lord, this is 3393. They have stated 3392 wrongly. I said 3393, the second case.
What will happen to all these dictations?
My lord, the facts are the same, my lord.
Let it remain like this. Suffer. I'll help it. Be careful, yeah. You need to tell me this is, you know about the amount. That is why I didn't understand that this is wrong. I'll help it. Let these matters go after brigade. So you should be more careful, Mr. Bora. Are all amounts the same 621?
No, my lord.
Then why didn't you tell me?
It's different transaction. So only the 3417 and 3392 would have covered the course of action your lordship was outlined.
We do one thing, we dismiss your petition easily. Saying that it has been closed, as I said, unless you challenge that order, nothing remains. No, that order is there now on affidavit.
I apologize.
We close it on that basis. Your petition becomes infructuous.
I don't think kindly.
No,
I don't
absolutely.
take it up
not.
after the vacation.
No, nothing doing. They have taken the year for disposing of, I'll dispose it of. No, I dispose it of in this manner, it has become infructuous.
I don't think kindly take it after.
Go before the division bench. You should have been more careful.
My lord, I apologize. My lord,
No,
for the-
nothing doing. I've already taken up the time. You're dictating half the way and now therefore when I get it, now you say this.
My lord, actually the affidavit, my
It
lord,
is
it was not
subject
with
to
me.
cost.
I just got, my lord, I just got the
You have
affidavit.
to impose cost upon you.
My lord, they kindly,
How much is the amount? 16,35,000. 10%.
my lord, may kindly not impose cost. I withdraw my name from the wakalat number, let the account line.
No, you.
My lord,
Cost is 1,65,000.
my lord, may kindly,
It's all the time.
my lord, I apologize for this.
No, I was dictating half the way, then I really got it.
My
It
lord,
doesn't go
my
gel
lord, I
with
had
what you
initially-
are submitting.
My lord, I had initially intended to file the rejoinder affidavit. That is,
No, nothing doing.
my lord, may kindly,
Proper लेखक है लेकिन आपको है तो जो क्वेश्चन में 3392 ना लिखी तो 932 ने लिखी 3392 and 3417 ये आगे एक ही सब काटी दी लाइले डिक्टेशन दी the petitioner herein एकदम फर्स्ट पैराग्राफ तो था कि ना that's the WPC number हाँ the petitioner herein, the case of the petitioner herein is 3392. Is that on 23/9/2023, a transport vehicle bearing license number AS01DC 1037 transporting pan masala product was intercepted by the respondent number 3 and detained due to some discrepancies involved therein. Accordingly, proceedings under section 129(3) of the Assam Goods and Service Tax Act 2017 were initiated. For short, the State Act. And a so-called notice dated 5/10/2023 was issued to the petitioners. The petitioner thereupon submitted the reply thereto on 9/10/2023, rebutting the allegations raised. Subsequent to the said reply, the respondent number 3 passed an order under section 129(1)(b) of the State Act, as well as the Central Goods and Service Tax Act 2017, determining the tax, quantum of penalty and cess payable at rupees 16,35,840. The petitioners, taking into account that the goods in question were perishable in nature and delay and not making the payment of the demand of tax and penalty would result in detention for unduly long period of time, paid the amount of rupees 16,35,840 via net/online banking on 19/10/2023, which was duly acknowledged by the respondent authorities. Thereupon, the detained goods were released upon payment of the entire demand amount on protest by release order dated 20/10/2023. Full stop. Thereupon, the petitioner company tried to file an appeal against the demand order dated 13/10/2023. And upon trying to file the demand appeal, an alert notification kept cropping up in the what site?
The website of the central government, some state government.
In the portal.
In the portal.
To the effect that the appeal could not be filed, appeal could only be filed after complete payment of taxes as calculated in table 15(a). The petitioner was shocked and surprised at the said aspect, taking into account that when the entire demanded amount had been paid under protest and reserving the right of filing an appeal, as to how such alert notification kept cropping, for which the petitioner submitted 2 communications dated 6/1/2024 and 2/3/2024. The petitioner therefore apprehended. Therefore, in terms of, as per the petitioner, that the glitch which had occurred in the portal must have been on account of the officer concerned has not set off the deposited sum of rupees 16,35,840 Full stop. On the ground that the petitioner have been deprived from filing the appeal for no fault of the petitioner, the instant petition has been filed for appropriate directions and orders. First, WPC number 3417/2024. The facts involved in the instant writ petition are similar to WPC number 3392/2024. However, the difference is that the vehicle which was intercepted was license number AS01Y5425 on 2/8/2023. In the instant case, the show cause notice was issued on 3/9/2023. And the petitioner submitted a reply on 12/9/2023. On the basis of that, initially, the tax quantum of penalty and cess was determined at rupees 24,12,288. However, subsequently, the same was revised to rupees 16,08,192. In the instant case, the petitioner paid the same amount on 6/9/2023. And the authorities duly acknowledged the receipt of rupees 16,08,000 duly acknowledged the receipt of rupees 17,50,000. Isn't this?
My lord, this is slightly more than the amount. My lord, this is more than the amount. So one at page 61, 1750. At page 61.
Yes, that is what 17,50,000.
50,000.
Thereupon, the petitioner tried to file appeal against the order dated 4/9/2023. However, the appeal could not be filed on account of the same glitch of an alert notification kept cropping up to the effect that the appeal could only be filed after complete payment of taxes as calculated in table 15 bracket A. Under such circumstances, the petitioner in the instant case had submitted two communications on 2/12/2023 and 17/2/2024. However, nothing was done for which the instant writ petition was filed. Full stop. Was the appeal filed or not?
Not be- Only way is when e-filing.
Huh?
Only way to file an appeal is through the e-method. There is no hard copy method of filing.
Now, what is this document, page 73?
That is the format of the appeal. It was never filed.
Puस्तक. Being agreed. Next, huh? There would be terrible. Being agreed. Both the above writ petitions were filed, and this board, by various orders, issued notice and also observed that the pendency of the writ petition shall not be a bar to the respondents to proceed with the appeal. Pusto. This court have also taken note of that on various dates, orders have been passed in the instant writ petition, inquiring with the respondent authorities as to whether the glitch was removed, taking into account that the petitioner have duly paid the said amount. However, on various dates, instructions were sought for on various dates, it was informed that the instructions are awaited. On 11/9/2024, this court observed, directed the respondent authorities to apprise this court as to whether the payments so made by the petitioners have been duly reflected, inasmuch as on account of non-reflection of the said payment, the petitioners were not in a position to file the appeal. Accordingly, two respective affidavit in oppositions have been filed in both the writ petitions. The stand which have been taken in the affidavit in oppositions is that Mr. Gogoi, you should have been more careful. What you are admitting, kindly see of the affidavit in WBC number 3417.
My copy is before you. Yes, sir. On the parallel-
They have paid 16,08,000 is the demand. They paid 17,50,000. You say that he have paid 24 lakhs, which was the original demand. See, be careful. These are on affidavit.
It is the instruction manual of the parallel is there.
It can't
It's
be.
the exact figure.
Which is similar in content. The specific stand which have been taken in both the affidavits, that as the demand were paid, comprising of the tax, penalty, and cess was paid in full. The proceedings initiated by the notice dated 4/9/2023, by the notice in both the writ petitions, stood closed. stood concluded. Or in other words, the stand which have been taken now by the state respondents, that too on the basis of an order dated 19/9/2024, that too when the instant petitions have been pending for the last three months, no? 3 months.
Regarding my lord, section 129(5). Proceed kindly on the moment.
Writ petitions have been pending for the last 3 months, wherein the grievance of the petitioner is specifically at the is specific to not being able to file the appeal. The respondent authorities have concluded the proceedings on the basis that the petitioner have paid the dues along with applicable interest and penalty. During the course of the hearing, Mr. B. Gogoi, the learned counsel for the Finance and Taxation Department of the Government of Assam, submitted that in terms with section 129(5) of the State Act, upon payment of the amount referred to in subsection 1, all proceedings in respect of the notice specified in subsection 3 shall be deemed to have been concluded. He therefore submitted that it is in exercise of that power the communication dated 19/9/2024 have been issued.
Disposing and directing the authorities to kind of take a hard copy of the appeal. The directive, they have submitted the representation, specifying that technical claims. Let them take a call there in the representation, which is pending for the authority.
No, it has to be an appeal.
But he has submitted the representation informing the authorities that despite his repeated attempt to upload the appeal in the portal, because of the technical glitch, he has not been able to do that. Let the authorities take a call, if they found that yes, something because of their our fault, he could not file the appeal. They will entertain the appeal immediately. If not, they will pass a reason out. There may be some reason. Because representations are
That is not your answer, no? He has made specific requirements.
But he has made a representation, he has annexed in the liquidation, all three. Otherwise, in that line, it can be disposed of. Within a time frame.
I've heard the learned counsels appearing on behalf of the parties and given my anxious consideration. First, Section 107 of the State Act of the Central Goods and Service Tax Act 2017 categorically stipulates that any person aggrieved by any decision or order passed under the CGST Act 2017 or the State Act, as well as the Service Tax Act or the Union Territory Goods and Service Tax Act by an adjudicating authority may appeal to such appellate authority as may be prescribed within 3 months from the date on which the said decision or order is communicated to such person. In terms with section 1076, no appeal shall be filed under subsection 1 unless the appellant had paid either the amount in full or such part of the amount of tax, interest, fine, fee, and penalty arising from the impugned order as is admitted by him, or a sum equal to 10% of the remaining amount of tax in dispute arising from the said order. The proviso to subsection 5, subsection 6 to section 107 categorically stipulates that no appeal shall be filed against an order under subsection 3 of section 129 unless a sum equal to 25% of the penalty have been paid by the appellant. In both the cases, it would be seen that the petitioners herein had made the entire payment of tax, penalty, and the cess, which have been duly acknowledged by the respondent authorities. It is further seen that the petitioners have also within the period permissible to file the affidavit appeal had submitted representations as aforementioned, stating inter alia the reason why the entire amount of tax, penalty, and interest was paid as demanded by the final order passed under section 129(3) of the State Act. It is also seen that during this period, during the period of limitation, the petitioners have also informed the glitch which was showing when the appeals were filed. And it was also duly intimated that the amounts so demanded were paid under protest. However, in spite of the representation so submitted, the petitioners herein could not file the appeal in the portal. Full stop. This court have also perused the provisions of section 107 as well as 129 of the State Act. Whereby it does not, whereby the provisions thereof do not in any manner act as a bar in payment of, in filing of an appeal if the entire demand as stated in the order passed under section 129(3) of the State Act have been paid. Section 129(5) only stipulates that upon payment of the entire amount as referred to in subsection 1, all proceedings in respect to the notice specified in subsection 3 shall be deemed to be concluded. The said provision, therefore, envisages a situation when only the notice have been issued, wherein envisages a situation the said provision, therefore, shows that that upon payment of the amount The proceedings in respect of the notice specified in subsection 3 shall be deemed to be concluded. But the same would not bar in filing an appeal under section 107 taking into account the above. This court is of the opinion that the respondent authorities, for the fault of the respondent authorities, the petitioners, were not able to file appeals against the respective orders passed under section 129(3) of the State Act. Accordingly, this court therefore disposes of the incident with petition, thereby directing the respondent authorities to either remove the glitch either permit the petitioner to file the appeal within 7 days from the date of the instant order on the portal, and if the same is not possible, the appeal be accepted in the manual mode if filed within 7 days thereafter. With the above, both the writ petition stands disposed. Now, why you are filing an appeal?
Because we have already paid.
No, why you are filing an appeal in the third matter?
Because there is a question was raised in earlier proceedings similar.
No, there is no order under 129(3).
No, my lord, in third matter, my lord, in 3393, there is a provisional assessment of 6 lakh, that amount. So the question of law limitation can be raised before the appellate authority as well as before your lordship.
No, I'm not on that. Why you are filing an appeal?
In this matter, my lord, provisional assessment, because.
But they have not decided till now the decision.
Yes, my lord, because that is what I did. They have not given the final demand.
So as of now, they have not decided.
That my lord, that question of law, I may be permitted to raise before the authority, or I'll raise before this honorable court, because that has been quashed and set aside. The prior hearing is to quash and set aside the proceedings.
So this is not for appeal business.
No.
Again, here also appeal. Same prayer.
You can pray, my lord.
Here also you tried to file an appeal.
My lord, and to refund the whole proceedings have been vitiated, my lord. Appeal on the ground
To
of
direct the
refunding.
ER to refund the amount. No, update the payment because you want the update and update you want it.
Yes.
Why? For filing the appeal.
My lord, yes.
Then why are you asking for filing an appeal? I don't understand now. When they have not passed the final order, if it is not passed, we set aside on the basis of limitation. Within 7 days, he was opposed, he has not. We set aside directing you to pay the amount.
I'm agreed.
The act says 129(3). You have to pass within 7 days. You take your instruction whether that order has been passed. Mr. B. Gogoi, the learned counsel for the Finance and Taxation Department of the Government of Assam shall obtain instruction as to whether the final order has been passed in terms with section 129(3) of the Assam State, Assam Goods and Service Tax Act 2017, pursuant to the show cause notice issued on 10/11/2023, and the reply filed by the petitioner. You file your reply on
10/11 itself.
Huh?
My lord,
what? On 10/11/2000, and pursuant to the reply filed by the petitioner. Taking into account that it is the mandate of section 129(3) of the said act that the order to be passed is within 7 days. List the matter again on before vacation. 30. Yes, any urgent matters?
Item 36, my lord, that interim order is still today. The GMC authority has not filed that affidavit, my lord.
Oh, that one,
That one, my lord.
Anand Jalpan or
Yes,
something.
yes. GMC authority has not filed the affidavit.
DMC authority likes you are working, functioning.
Hello.
That is why they like your functioning day.
I have received my instruction today.
Huh?
Today I have received my instruction.
Then you want to file. Okay. Mr. Esbora, the learned counsel appearing on behalf of the GMC submits that he has received his instruction and he needs 2 weeks' time to file the affidavit. This matter again on 30/10/2024. The interim order passed earlier shall continue till then. The GMC shall file the affidavit on or before 23rd of October 2023.
It's item number 53, my lord. Contempt matter, I have filed an IA, my lord, for implement, my lord. That implement petition is already before Lords.
What is that?
These other 4 numbers of the officer already been transferred, my lord, and now the new officers have come.
Contempt.
Contempt matter.
Contempt against what?
My lord, this compensation, my lord.
Huh?
Compensation.
Compensation under?
My lord, since land was taken by the government, my lord, the Maya Patta land. Now already, as per the honorable court order, the communication has been made, my lord, the amount has been already fixed, my lord, 1,35 lakh something else. That has been communicated to the director of services, my lord.
Don't make these people party. Unnecessary, this will go for notice. Who is appearing for the government? Which department?
Deputy Commissioner is there, Dhemaji district, and the health department, madam.
This matter. It was item number?
43.
Contempt, when I see that they don't do anything, then I should, for that purpose. So that we initiate contempt proceedings, nothing else.
Lordship, find the 2713/24, my lord. IA.
The instant contempt proceedings have been initiated on account of alleging violation of the order dated 25/11/2022 passed in WPC number 1087/2020. Full stop. From the perusal of the said order, it reveals that the petitioner was directed it was it is seen that the state respondents were directed to pay compensation to the petitioner at the present market value, which however, market value within a period of 6 months from the date of receipt of the order of the court. Full stop. Mr. It is also seen that the payment is to be made by the payment is to be made by the requiring department of the government of Assam, the requiring department, that is the Director of Health Service. It will be the Health and Family Welfare Department. And thereupon the same would be released, upon being released to the Deputy Commissioner. Huh?
To the director,
The Deputy Commissioner, Dhemaji, can only be disbursed to the petitioner. It has been informed by Mr. G. Pegu appearing on behalf of the respond number 3 that the amount have been already assessed and the estimate has already been sent to the requiring department. Full stop. Mr. B. Gogoi, who was present in the court, is requested to obtain instruction as to what is the stage of the,
that proposal.
what steps have been taken in respect to the proposal by the Health and Family Welfare Department and apprise this court. Full stop. Accordingly, this matter on 23rd of October 2024. The name of Mr. B. Gogoi be shown in the cause list. We'll look into it later on. The instant order be brought to the attention of the present Commissioner and Secretary. The instant order be brought to the attention of the present Commissioner and Secretary to the Government of Assam Health and Family Welfare Department by Mr. Bigo, as well as the Director of Health Service. This will help you. Yes, what happened with this?
Proposal, yes, but now correct proposal has been given with the exact amount, my lord. Pay, my lord, some reasonable time it will be paid. Now they exact amount.
Can I perhaps pray that the matter be taken up once before?
No, they have created head of account.
Lordship will see them on the third page, my lord. Exactly.
I'm sure Mr. Gogoi have made this for them.
Yes, my lord, I have to, my lord.
Yes, they've been done. A payment of medical assistance to so one will be required to be. One some monthly stipend, 12 is the month.
39.
The payment to the creditor.
Exactly.
This has been done. Proposal, what has happened now?
Now it has been sent to the government, my lord. They are, my lord, expediting it, my lord. I pay notice immediately on the reopening if possible.
Okay. Item, what is the item number?
39.
But financial.
Mr. B. Gogoi appearing on behalf of the Health and Family Welfare Department have placed before this court that the proposal has already been sent for according sanction at an early date. And in that regard have placed before this court and a communication issued by the Director of Health Service to the Joint Secretary to the Government of Assam Health and Family Welfare Department. The same is kept on record and marked with the letter X. Mr. B. Gogoi further submits that in the meantime, sometime within so that the matter has been taken on an urgent basis and then within a short period of time, the same would be accorded, the sanction would be accorded and the payment be made. Full stop. List this matter again on 22nd of October 2024, on which date this court directs the respondent in the Health and Family Welfare Department to take appropriate steps so that the amount can be released on or before the next date, on or before the next date. Okay. There are no more urgent. That's good.